Item 2,
May I please?
yes, please.
Last occasion, you lost direct to take instruction on the concern.
एगार 10-20-23
7/11/23 you lost yours.
छत्तीसगढ़ लोकल एरिया रेसिडेंस में किसी आसिला कि
My lord, he had sent today morning. I have also discussed, my lord. He has already sent.
Mr. SR, you are Mr. Raut.
KC Behra.
Mr. KC Behra.
Yes, ma'am.
For the petitioner, K. C. Behra for the petitioner, Mr. S.S. Mahapatra, AC for the state. Mr. Behra, actually it is very difficult from other states.
My lord, there is a custody since more than 1 year.
I understand.
The difficulty.
But I cannot tell you more than that.
No, it's a transfer of
No, I cannot tell you more than that. What is the response of the DGP or the IG of the other state?
They are not responding. But even 3 days back, he has again.
This state, I can right now appearance by two. I mean, hypothetical. Dude, I don't like. I can direct the appearance of the head, but they are not responding.
And also, the petitioner was a roaming person, my lord. He was to Madhya Pradesh, he was to Chhattisgarh and different places. Commission of.
At times they are non-committal also. Ame kahin karu. That's the other difficulty. And when I am saying that, I mean, they are not responding, that is beyond the experience of a lawyer also. It's not that only as a lawyer I have the experience.
Well, if your lordship please to release, if your lordship please, then if your
law religious. Upon your lordship को God को say equivalent कर दो ना थी. That's a mistake. It's a right of the individual. I don't have a choice. I have to release him. But a balance has to be drawn. And balance is in these kind of cases is that I am myself searching for a person who has escaped bail and went away to West Bengal. At least I have passed 4 orders. It was not my order. So item 1, if I take that matter and item 2, your matter, what will be my mentality? Please appreciate, I am a human being. In many of the matters, the learned counsels are simply not appearing where they have jumped. Ki interim bail galani, ki galani mane ko agote case remand he ki se case bail asi ki se case appear na kari palelani. At least 2-3 case re to local apanakar jump kari palechandi. I am again and again adjourning and seeking instruction. Outside re gote West Bengal gote matter re Ganjai case re from Ganjam or maybe at Gajapati, maybe Ganjam. I am still waiting that person will appear. Day before yesterday, somebody jumped bail and files an affidavit, daring affidavit, that the period has not expired, so it may be extended. I didn't write that it's a deliberate because I cannot say for the Muka Manavitartha Pasini, I simply wrote that it is inadvertence or otherwise. Otherwise is a big quote unquote. Then how the court will trust?
he will appear.
Wherever he appears, he has to be released. He has to be released. I do mean to say that where the persons have jumped, there were no conditions.
Yes.
Then how the court knows it? Because there is a condition. It's very difficult. It's very difficult. You are right. That is how I am spending time with you. You are right. That this person is languishing behind bar. But you see, he has been abandoned by his family. He has been abandoned by his family. His family could have lent some support. That can be done. Maybe that matter is item 3, which I am just discussing with you. Sorry, that order was a yes. The learned AC submits that he has been making efforts to contact the contact the SP of the local area of residence of the petitioner through the state police of the Odisha state, so through the police of the state of Odisha. However, the response is yet awaited. The response is yet to be received in terms of the order dated 11/10/2023. केबे आनिबा?
After 2 weeks, Lordship. After reopening.
आज prayed for. नहीं, list on sentence change करो तो list on 4/1/2024. Instructions are being obtained in terms of the order dated 11/10/2023. The learned counsel, Mr. S.R. Rao, submits that the petitioner is languishing in jail custody since so and so date.
24/11/22.
24/11/2022. Ekon Ganjai.
No, this is my lord. 457, 380 earlier it was registered, but it has turned to 394 and 450. It is live conviction.
ଆପଣ affidavit ଦେଇଛନ୍ତି past antecedents?
No, my lord.
ବଢିଆ.
There is no.
It's a great tragedy, sir. Every time the January 4 ରେ ଆପଣ time ନେବେ ସେଥିପାଇଁ ଭାବନ୍ତୁ. ଆପଣ ଏଟା ଫାଇଲ କେବେଠୁ କଲେଣି?
File
4 ମାସରୁ.
is file.
3 ମାସ ପୂର୍ବରୁ I find there are some orders by Justice S.K. Sahoo prior to March. This is listed for the first time on 22/3. नहीं February 4 ରୁ file କଲେଣି ଆପଣ. You have spent time for 1 year. Just imagine what you are doing.
I will file. There is no action.
ଆପଣ କଣ how you are wasting time, do you realize? ଆପଣ affidavit ଟା file କରିଥିଲେ ସେ ସେଇଟାକୁ ପଠେଇ ଦେଇଥାନ୍ତେ ସେଠିକି ଆଉ instruction ଆଣିଥାନ୍ତେ. That would have been much easier. And even if you do not have the exact instruction, the practice is, even if the affidavit, the contents of the affidavit doesn't match the police report, still opportunity is given. Why the opportunity is given? Because you are not aware. The lawyer has a difficulty to know the exact details. If that is the trend, then subsequently the other bench. I'm the third bench since last 2 months or something like that.
No, I'll file my.
So you should have. You are not proactive, and also you find out who will be the family member and the local security. Get those things ready.
Yes.
If they get the instruction, thereafter also you require these things. And a person who is roaming around the country and committing crime. That's the background. You are seeking bail for him in the 439. What is the consideration for a court? You have to address that. Then why you are sitting over it for 12 months?
Sorry, my lord.
No, not sorry.
There is no direction.
I feel really, then I will not interact.
No.
I am not a fault finding mission. You are in robes. You are representing something. So I'm asking you, and you have to be ready to face these questions.
Yes.
And you are a regular practitioner in this branch. You are aware that court is seeking affidavit on behalf of the petitioner regarding the past allegations of criminal activity. It gets verified through the state. Then wherever there is a, maybe at times these people are not getting, but I am thinking that yes, if you give local security, family member stand security, then the court can consider. Upon the January after Arjun Kuri, I am sure you will not file it.
No, man, I'll file finished.
दियो तो डाले. List on it. चल.
Oh, bless me.
Dictation search. Yes. Next item 3.
Item 3.
2-3 minutes, lords.
This is जो jump करी.
Yes, lords.
Asiole. It's a mere coincidence. ये local resident.
Yes, lords. Report is at Clark units.
ଏବେ 12 ରେ ଇନିସିଏଟ ହବ ତାଙ୍କ ଅଗେନ୍ଷ୍ଟ ସିକ୍ୟୁରିଟି ଅଗେନ୍ଷ୍ଟ ମିସ୍ କେସ୍ ଇନିସିଏଟ ହବ. ସେ କେବେଠୁ ଜମ୍ପ କଲେଣି?
6/11 lordship warrants.
11/5 ରୁ 7 ମାସ ହେଇଗଲା. And this is not a normal routine work of the High Court. Since there is a bail order, High Court cannot escape it. If somebody has jumped, then High Court cannot dispose of the matter also. In terms of the earlier orders passed by this court, The Lord Additional District and Session Judge Paralakhe Mundi, District Gajapati. Gajapati, not Ganjam, Gajapati. So I was also thinking that. Gajapati has provided instruction by letter number 4716 dated 12/12/2023 to the Register Judicial of this court, which is placed on record marked as flag K. In the said instruction, the following has been stated. Reminder, last page अच्छी देखिए 6टा line, last 5टा line. Reminder is issued to ... made. Para. In view of the instructions received from the learned AD and Session Judge, Paralakhe Mundi, District Ganjam, the matter be listed on 8/1/2024. Registry shall intimate the today's order to the learned court, to the learned AD and Session Judge to obtain up-to-date instructions by 5/1/2024. 8,010 कर दियंतु 5 दिन गैप रो. Yes.
Item 4.
Up-to-date instruction regarding production oblique appearance of the petitioner accused.
Item 4.
Item number 4, my lord.
4, Mr. Mahapatra.
My lord.
Yes, my lord, here I have taken the instruction that the case is now trial is completed. The case is posted for accused statement.
Accused statement.
Yes. Your lordship may dispose of the application with the indication to dispose of the case. Only the accused statement. No
vested right to expedite the trial unless there is only one case. If that court is having on its board only one case, then because somebody is coming to High Court for seeking bail, I will try to, what about persons who are languishing earlier than him, who will expedite?
Looking into the
administrative court.
Lordship can say as expeditiously as possible.
No.
And so far the other aspect is
No direction, sir. No direction. Somebody coming to High Court seeking bail, his case will be expedited, and those who are languishing since time immemorial, you can say. It will not be exaggerated thing. The kind of pendency we are having, so many cases. Those only who come to High Court, they will get an order for expeditious disposal. It defies all logic. It violates the right of others. You have to make all the persons a party then, if I want to score a march ahead of them.
No, not in that way.
No, I will record this with all seriousness. You must have marked. That's a complaint that I am recording everything. I am not hesitating to record the reasons. Why you will score a march over the other trials who are languishing ahead of you? That's the short point I have to answer here. And your trial will be expedited. And just think about the acquittal rate. Conviction rate. Unless you make out a case that's the only case the court is not taking up.
No, that I cannot submit because
then my order is laughable, Mr. Mahapatra. Don't I request me to pass a laughable order.
this is the situation so far the gas part is concerned.
Decide what to do in your case. For expeditious also, you have to file a BL appeal also. For expeditious trial, you don't have to file a BL appeal.
No. For that purpose, I have not filed because
it can't be subterfuge also. Either way. BL appeal cannot be a subterfuge to obtain an order of expeditious trial. Then you have to make all the under trials a party, those who are languishing. Prioritizing a trial is a gross injustice to other persons. Gross injustice, those who are under trial, languishing. You may say that others have got bail, no one is there inside. You decide what to do.
For the cash security concern, I have taken instruction that he is not in a position to furnish any more cash.
That's sir, you are. I'm not seeking or you are. I'm not seeking any bargain from any accused, sir.
No, my lord, I am not saying that.
Please don't make those statements. I always tell that I'll give all the reasons because I have to respond as a judge when a lawyer is making a submission. That's the sole purpose. When you are stating that as far as cash security is concerned, he's a pauper, he can't furnish. So how the court is concerned with that? The law requires that. The judicial trend requires that. How much money you have swindled before becoming pauper? Total money kete, Mr. Raut?
21 lakhs.
21 lakhs in my case. Total is 1 lakh, 1 crore pacha.
Yes. Mr. Mahapatra, after swindling 1 crore, you have become a pauper. You have to face the consequence.
Here the case
At least none of the victim is taking that ground that we have become proper because my entire life saving has been swindled by somebody who has now become a state guest. You adjourn it, you can, if you are unable to make up the mind, you are just muted. So this is a heavy board.
No, I am not muted.
It's a heavy board. These questions you have to ask to your client or a briefing counsel. To that extent, at least I am spending time with you. These questions you have to ask. Somebody becomes pauper after swindling 1 crore, what would happen to him?
Otherwise, your lordship.
From that, you have to read that Subrat Ray Sahara judgment, where he himself addressed 4 or 5 eminent senior lawyers addressed the Supreme Court regarding the viability of Subrat Ray Sahara and how the company is good and what is the response of the Supreme Court. When he was finally sent behind bars, he is no more. He is no more. He has passed away, I think, recently.
Yes, yes.
You read that judgment, then you'll realize that when a swindler, alleged swindler, takes the plea of what? Abject poverty.
My lord, I answer it.
So should I observe regarding your submissions or I should not observe anything?
Your lordship may not.
Fair enough. Fair enough. The Lord Counsel for the petitioner, Mr. Mahapatra. Tiptiranjan Mahapatra on behalf of, you are along with Pasat.
No, Somnath Satpathy. Because the
Satpathy for the petitioner. Mr. S.S. Mahapatra, Additional Standing Counsel for the state. Mr. Brindavan Raut for the informant. The Lord Counsel for the petitioner seeks further accommodation. As the Lord Counsel petitioner submits that content. Petitioner counsel for the petitioner refers to the earlier orders dated 24/11/2023, 2011/2023, and also the earlier orders dated 7/11, 6/10, and 18/10. And submits that he has not been able to obtain any up-to-date instructions from the petitioner and may be accommodated further. As prayed for, when do you want, Mr. Mahapatra?
Your lordship may call this matter after in the first week of January.
First week बहुत matter अच्छी जो 4 दिन अच्छी, so don't make it first week. आज pleasure होची आजी. You should regret that after when I considering the matter, I am adjourning it. So my best pleasure would be, most pleasurable would be to dispose of the matter.
No, I pray for adjournment convenient to your
Because you are
lordship.
persuasive enough, I have to adjourn it. And very muted in your response. Yes. Please turn 8 ना केते गोटे फास्ट डेट केबे अछि सही भी केरो डेट कर दियंत 12/1/2024 to grant further opportunity to the petitioner. Yes, the Lord AC submits that case diary is available.
Yes, ma'am.
Available, and he shall also obtain up-to-date status of trial.
Item 5,
Item 5, prepared for after vacation month.
Your name, sir?
Satyabrata Das.
You have power here.
Ma'am.
Mr. Satyabrata Das for the petitioner. Mr. S.S. Mahapatra, AC for the state. That instruction in response to the affidavit has been received, Mr. Mahapatra.
My lord, received, he is having one more criminal antecedent.
So,
He has to file further. He
Learned
will
counsel
take,
for the petitioner.
note of this.
The petitioner seeks accommodation to obtain up-to-date instructions and advance arguments. Or as paid for list after vacation.
My lord.
As paid for list on 11/1/2024 to grant further opportunity to the petitioner. The learned ASC submits that he has obtained up-to-date response, up-to-date instruction in response to the affidavit on behalf of the in response to the affidavit filed on behalf of the petitioner. Check it, amend your affidavit or file a further affidavit.
My lord, that may be reflected in affidavit. The
No, you have mentioned one case, but we have another case. You take note of it and take it.
Court record deliberation होची से सॉरी वाला पर अपन कुछ नहीं file one case. What is this?
sir,
You are stuck. You are stuck there. You should be attentive. How he responded, what the court directed. And purposefully, I am not observing that because that will lead to dismissal of the petition. If you are not approaching when you are seeking indulgence, you are not disclosing. It's a relevant consideration in 439, your past activity. Yes.
Item 6.
Taken after vacation.
Mr. S. Mahapatra, even Mr. P. Mahapatra.
No, S.A. Happy.
Mr. S.A. Hafiz for the petitioner, Mr. Standing Counsel for the state, Learned Counsel for the petitioner seeks accommodation due to non-availability of the learned senior counsel. Here the senior is appearing or you are appearing.
I am asking.
Senior going to engage in Nanti. As prayed for, when do you want, sir?
After vacation, Lordship.
Second week.
Second.
16 as paid for list on 16/2024 to grant further opportunity to the petitioner. The learned standing counsel submits that the case diary is available. Case diary ऊपर standing counsel लिखी है appearance टा. हाँ. Yes.
7.
Obliged.
Mr. S.K. Patnaik, that is good. He is taking adjournment in absence of you. That should not happen. Mr. S.K. Patnaik for the petitioner. Mr. S.S. Mahapatra AC for the state. The learned counsel for the petitioner seeks further accommodation to advance arguments as prayed for. Kebe.
January 2nd week.
Second week. See, second week, third week, which week as prayed for 17/1/2023.
Obliged.
Now, in case of change of roster, this wherever the roster goes, he will think that this judge was only adjourning matters. Yes.
Item
May I please your lordship? May I please your lordship? Offense under 376(1), 354.
I'm sorry. Mr. Ashutosh Tripathi, just a second. Gotte sentence ke liye aage order tha achhi. The Learned AC submits that the case diary is available.
Yes, ma'am.
Yes.
My lord, last occasion କୁହାଯାଇଥିଲା ଯେ ମତେ ଫାଇଲ କରିବା ପାଇଁ ଡିପୋଜିସନ କିନ୍ତୁ ଆନେସର 3 ରେ ମୁଁ ଫାଇଲ କରିଛି ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ପ୍ରେଜେଣ୍ଟ ପେସେଣ୍ଟର ୱାଇଫ ର ସେ ଆସିପାରିଲା ନାହିଁ ଆଉ ସେ ଆସିଲେ ମୁଁ କହିଥାନ୍ତି ଯେ ଓକିଲ ଥିଲେ ତାଙ୍କୁ କହିଥାନ୍ତି କପି ଆପ୍ଲାଏ କରିବା ପାଇଁ ତାଙ୍କ ଦେହ ଖରାପ ଯେ ଆସିପାରିନି
ଆପଣ ଟାଇମ ମାଗୁଛନ୍ତି ଆପଣ ଠିକ ଅଛି ଆପଣ ଚାହୁଁଛନ୍ତି ଡିପୋଜିସନ କପି ଆସିନି ଆପଣ କିଛି ସମୟ ଦେଲେ ଫାଇଲ କରିବେ ତ
ଆଜ୍ଞା
ହଁ ଠିକ ଅଛି ମଚ ବେଟର ଆପଣ ଏକ୍ସପେଡିସନ ଷ୍ଟାଇଲ ଚାହୁଁଛନ୍ତି କି anyway Mr. Ashutosh Tripathi for the petitioner, Mr. S.S. Mahapatra AC for the state, Mr. Dilip Kumar Das, DLSA, Dilip Kumar Das for informant oblique victim. The appearance is order likhuntu. Mr. Ashutosh Tripathi for the learned counsel for the petitioner and the learned counsel for the informant, public victim. Into bracket लिखिए engaged through the DLSA. हाँ, bracket closed. Being present at the virtual court, Orissa High Court at Hon'Ble. सेटा के पछड़ा जो देखा जाउनी मु केतरा कहलेनी टिके भलरे सेटा को फोकस करियो ना दियाडो हबनी दीटा कैमरा दरकार ना कोन से गोटे कैमरा रे हबनी Hon'Ble एते तो देखा जाउछ Hon'Ble address arguments plural address arguments. The learned counsel for the petitioner referring to the earlier order dated 4/12/2023 submits that he may be accommodated to obtain the copies of the depositions of the PWs to address arguments. How much time, sir? Mr. Tripathi? January को week, second week.
Second week one.
As prayed for list on 18/1 2024 to grant further opportunity to the petitioner. The learned counsel for the petitioner shall also provide copies of the deposition to the learned counsel for the state to enable him to obtain instruction and also file the same before this court for consideration. Yes.
Item 9.
Item 9 kindly taken up after vacation.
I'm sorry, I forgot your name.
Item
Sorry.
Saubhagya Lakshmi Pat.
Miss S. Patnaik. No, you yesterday you appeared. I noted. On behalf of Dilip Kumar Das, Amita Tripathi. Saubhagya Lakshmi Patnaik on behalf of Amita Tripathi for the petitioner. Mr. S.S. Mahapatra, ASC for the state. The learned counsel for the petitioner seeks further accommodation to advance arguments. As prayed for list on 19 January.
Yes.
19 January 2024 to grant further opportunity to the petitioner. The learned the learned ASC submits that case diary is available. Sub-item is a connected matter. Same affair.
Yes, my lord.
Same order.
Same order. All these be
Yes.
together.
Item 10.
10 is same, my lord. 10 is of same matter arising out of the same incident.
मैडम आपणकर आ गोटे मैटर रे से सूर्यकांत द्विवेदी अपेयर करछंती 10 टा
Yes.
आपणकर ना लिखि देले चलिबो अर्जुन तो मु नै परिबे
Amita Tripathi on behalf of Amita.
नहीं नहीं सॉरी आपण लिस्ट टे देखंतु इडी लिस्ट गोटे रखछन देखंतु आइटम 10 देखंतु
Item 10 रे सूर्यकांत द्विवेदी नाम माइनर हमर आइटम में
आई एम सॉरी ताले सब आइटम टा कहा ना रे लिखिबे
9 रे सब आइटम सूर्यकांत द्विवेदी
आपण ना लिखि दोछ अछि तो नांती कोन करी फेरे अरे गोटे ऑर्डर केमती अधा है कि रहबो आ गोटे ऑर्डर केमती बता
Yes ma'am.
मिस पटनायक ऑन बिहाफ ऑफ सूर्यकांत द्विवेदी कर देबे बीएल 6750 सब आइटम रे हैला 10 टा भी शेयर कर देबे पटनायक ऑन बिहाफ ऑफ सूर्यकांत द्विवेदी यस केस डायरी इज अवेलेबल सब बाकी सामान रहला मिस्टर एसएस महापात्र यू कैन इन्फॉर्म मिस्टर द्विवेदी
Yes.
no one is there for him and
Yes ma'am.
yes next 11
11.
cited witness charge sheeted witness
My lord.
दिजोर एग्जामिन नहीं सालेनी
My lord.
अच्छे कौन आता है अर्जन कर देला ना करना वो ना 2 PM
Quantities,
नहीं स्टेटस ऑफ ट्रायल वास्ट है
lordship.
it says 3 number of witnesses cited as prosecution out of them 2 witnesses have already been examined cross-examined and discharged
Well.
now the case is posted on 6/1 for recording of evidence of SISS so now the ठीक है आसंत
Well.
pass to be taken up to be called again at 2 PM
12.
Tripathi
was the husband.
yes
Offense under section initially FIR lodged under section 498A 306 minute.
Yes.
And the
DCM report ଟା ଆସିଲା?
Yes, madam. As
Yes.
this is
ଆପଣ ଦେଖିଛନ୍ତି?
as such, no injuries there. madam.
Before we start deliberating, let all of us have the copies. Now after 12 minutes,
I have already.
you have seen. Confident.
Minus.
Lock କରି ହବ ତ? ଠିକ ଅଛି, good.
As it seems, my lord, PM report, my lord, no injuries there. my lord. That's why, my lord, 306, I thought
ଆରେ
that,
ବିଷୟରେ ତାହେଲେ injury level ବିଷୟରେ ଦେଖିବାକୁ ପଡିବ.
my lord, the
That is a problem. That is a
suicidal,
problem for the petitioner.
suicidal hanging there.
Suicidal hanging, যদি ଆମକୁ after taking poison, if somebody administering poison, if somebody is hanged, antemortem poisoning,
Again.
so you have to see that.
No, though there is no.
Sir,
And one thing, my lord, the deceased has committed suicide in her house.
আচ্ছা এটা সেই কেসটা।
yes.
And they had a talk over phone.
No, my lord.
Or in the morning of the day, they quarreled.
2 days before.
Yes, someday.
2 days before, the petitioner came to the house of the deceased and scolded her. After 2 days, he has committed suicide.
No, not.
Mr. Sahoo is there. Yesterday he was arguing a suicide case of suicide without any injury. No, sorry, suicide with injury. He said that it is a case of suicide. No ligature mark. There is sufficient neck injury and death due to asphyxiation. But he was arguing it is a case of suicide by hanging.
But the occurrence took place.
No, that he has said. That he said. I mean, he's not fighting side of that thing. That there was a quarrel before that. That's the prosecution case, FIR case.
Before the occurrence, there was a quarrel and there was a
2 days. I was thinking morning, but he says 2 days before.
No, my lord. Actually, as for the my lord, the incident took place as on my lord,
The standing counsel, then you weaken your case by that. Upon जो ताल तो witness ना make your statement.
Yes.
पहले जैसे आस्तिले झगड़ा हला बोली.
yes. Mother statement is there. my lord.
संगे से झगड़ा हला.
Yes.
PW ना कौन 161 देखा तू ताले.
161. गत 4/3/2021 तारीख मतलब the postmortem has been done मतलब 6 मतलब that is on the Lord Messi
6-3.
early morning मतलब it was 6 मतलब
तामने चहला नहीं. 4 रे झगड़ा हला 5-6.
5 से
से 5 राति रे 5 राति 6 हला नहीं. से ठीक कहउचंदी.
5 रात रे that can be said 2 days back my lord. This is a 2 days back. 2 days back.
2 days back आपण जो आपण घंटा हिसाब करचंदी कि हमर जेंती
Yes.
period of bail hours 48 hours हे नतले आपण या कहउचंदी. Yes, I got your point.
4/3 रे
मोर कहया कथा जे 2 days no because 48 hours not completed. Okay.
postmortem report कहीं बाड़िया मरा गला that's why my lord I was my lord that postmortem report whether there is any injury as such
No, that can there is a possibility to but
there is no as such no injury. That's why my lord I have-
Mr. Amitabh Tripathi for the petitioner, the learned counsel for the first paragraph gala, second para. The learned counsel for the petitioner submits that the petitioner is incarcerated since 22/4/2023, and in the meantime, FPR has been final prosecution report has been submitted on date, sir,
27/4.
27/4/2023. तार माने 5 दिन भीतर दे देले.
My lord, what happened, my lord? The offense,
ना absconding करथले.
हाँ 6/3/2022 रे FIR ହେଲା. I have arrested after
22 Okay. 27 and considering the age of the petitioner being
my lord.
considering the period of incarceration, considering the period of incarceration and the age of petitioner being 35 years, he should be shown indulgence. As far as prayer for bail is concerned, para. The learned standing counsel in terms of the earlier order dated 28/11/2023, 6/11/2023 लिखिए 6/11/2023 reiterated on 28/11/2023 produces copy of the postmortem report and other relevant informations for perusal of the court. Para. The learned counsel for the petitioner submits that petitioner is a local resident, shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by such terms and conditions that would be imposed for grant of bail. Learned standing counsel, referring to the materials contained in the case diary and the nature of allegations, opposes the prayer for bail. Having had the learned counsel for the petitioner and the learned standing counsel for the state, considering the material on record, this court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in session of the matter. It shall also contain a condition that in case of any violation of any of the terms and conditions shall result in case the category violation of any of the terms and conditions, violation of public deviation from any of the terms and conditions shall result in filing a petition for cancellation of bail by the law enforcement agency / informant. Amar kon ki bearata badi dochon victim. 302 victim badi gale, 108 victim badi dochon.
Item 13.
Can you put 108 victim ki state সে তো রহিল আর ইনভেস্টিগেটিং এজেন্সি তারপর অবলিক ইনফরম্যান্ট অবলিক ভিকটিম লেখা আছে
Your Lordship, to file a comprehensive affidavit indicating
after you chewed my head, yes. ମୁଁ ତ କିଛି ବୁଝିପାରିଲିନି ଗଲା ତ ଆପଣ କଣ କହିଲେ କୋଉଠୁ ଆରମ୍ଭ ହେଲା କୋଉଠୁ ସରିଲା ଇଏ ହେଲା ୟେସ୍ ଆପଣଙ୍କର ଇନଫରମାଣ୍ଟ ପାଇଁ ଆପିୟର କରି ଆପିୟର କରୁନଥିଲେ
ନାଇଁ ସାର୍
ଠିକ ଅଛି
page 6 ଟା ଜାଣ
ସେଟା ଆପିୟର କରିଥିଲେ ଟିକେ ମାନେ କଣ୍ଟ୍ରୋଲ ହେଇଥାନ୍ତା ଆପଣଙ୍କ ସବମିଶନ ଟା
ନାଇଁ
ୟେସ୍ ନେକ୍ସଟ କୁହନ୍ତୁ
page 6 ଟା Your Lordship, please to have a glass at
ନାଇଁ ଆପଣ ସେ ଯୋଉ ମୋର ଡିସ୍କସନ ମନେ ଅଛି
sir do file your placement total out of 7 cases
ମାନେ ଆପଣ ସେଟା ଦେଇପାରିବେ ନା ଦେଇପାରିବେନି କଣ ସେଟା କଣ ସେଟା ଥିଲା what was the last order?
Yes, but today has come with the affidavit that will deposit 20,000 cash and rest 2,30,000 as proper security. Para 8 of the affidavit, Your Lordship, may kindly see.
affidavit sir କେବେ ଦେଲେ
affidavit sir ଆପଣ ଯୋଉ କହିଥିଲେ 7 ତାରିଖ ପୂର୍ବରୁ ଦେଇଛି
ଦେଲେ
6
again sir today you don't try for that item
6/12
today ଆଜି ଗୁରୁବାର ସେ ଆଜି affidavit ଦେଖୁଛନ୍ତି ଆଜ୍ଞା ଆପଣ ମତେ ମୁଁ ପାଉନି ଦେଖ flag
D, Your Lordship. D, madam. D,
ଓକେ 3011 ହଁ ପାଇଏ ମିଳିଗଲା ବସନ୍ତୁ
Para 8, Your Lordship, may kindly see.
ଏଇଟା ଏଇ କେସ୍ ରେ
sir
ଅନ୍ୟ କେସ୍ ରେ
ଆଉ ଗୋଟେ affidavit ଦେଇଛି
ଦେଇଛି।
sir ସେ case ରେ ଆଉ ଗୋଟେ affidavit ଦେଇଛି
so you are truly a vegetarian okay
ନାଇଁ ସାର୍ ଆପଣ ଇଏଟା ଦେଖି ଦିଅନ୍ତୁ
ନାଇଁ ନାଇଁ ଠିକ ଅଛି ଆପଣ ନଥିଲେ ମୁଁ ଗଲା ଥର ଆକ୍ଚୁଆଲି ବୋଥ ମିଷ୍ଟର ନାୟକ ଆଣ୍ଡ ମି वी ट्राई टू कैलकुलेट द अमाउंट କେତେ ବାହାରିଲା କେତେ ବାହାରିଲା କଣ ଆପଣ କହିଲେ ସୋ
ସାର୍ 6 ଟା ଯାଆନ୍ତୁ
କୁହନ୍ତୁ ସାର୍ ମୁଁ ଯାଉଛି
ଆଜ୍ଞା
ଆପଣ ଦେଇଛନ୍ତି ଥ୍ୟାଙ୍କ୍ସ ଟୁ ୟୁ କାରଣ ମୁଁ କିଛି ଆକ୍ଚୁଆଲି ହିସାବ କରି ବଡ଼ ଅବସ୍ଥା ଖରାପ ହେଇଯାଇଥିଲା ଗଲା
ନାଇଁ ସାର୍ ସବୁ ଜାଗା ଡିଟେଲ ଆପଣ ଲାଷ୍ଟ ଟାଇମ କହିଥିଲେ ଗୋଟେ କମ୍ପ୍ଲେନ୍
ସେକେଣ୍ଡ affidavit ମିଷ୍ଟର ଷ୍ଟାଣ୍ଡିଂ କାଉନସିଲ
Second affidavit. It is
କୋଉ ପାରାଗ୍ରାଫ ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ଦେଖିଲି ଫାର୍ଷ୍ଟ affidavit ପାରା 8
second affidavit na seda.
हैं
Seda second affidavit. First affidavit 2911.
नहीं नहीं बिल नंबर टा कौन देन
BL 6686.
हाँ 6686 कोटे
First
when
affidavit
7097 अपन ब्रीफ हैड नांदी
नहीं 7097 is disposed of the next is 6687
that case Your Lordship should not touch.
68
is
serial number
next item
अच्छा
14
ओके
14.
यस मु सब आइटम उडा क्लिक करथली अच्छा
No. 6686 Your Lordship may kindly see.
then Your Lordship on that last occasion directed to list it along with 7097/23
अच्छा ठीक अछि आई गॉट दैट पाइगली मु कोडा खोजि न माने मते लागला अपन टोटल आज दीटा केस आछि त
एई दीटा पेंडिंग अछि ता
ठीक अछि इन टर्म्स ऑफ दैट विल फाइल दैट affidavit बिफोर दैट कोर्ट
affidavit फाइल करछि देबी बोली केते टका कोर्ट सु
ए affidavit ता सर सेठी फाइल कर देबे कॉपीटा एटा एठी रहइबो कॉपीटा सेठी फाइल करियो गोटे वन लाइन affidavit दिस affidavit वाज फाइल्ड बाय ହେଲା that condition will be imposed ମାନେ ମୁଁ order ରେ ଲେଖିବି
Oblige.
copy of the affidavit shall also be filed before the learned court in season of the matter supported by one affidavit
Supported by.
ଯିଏ ଏଠି affidavit କରିଛନ୍ତି
ଆଜ୍ଞା ତା ମିସେସ୍ କରିଛି
ଯିଏ ବି କରିଛନ୍ତି ସେ ସେଠି ଗୋଟେ one line affidavit ଦେବେ the affidavit was filed before the High Court and refer to that affidavit
ଆଜ୍ଞା
Mr. Bikram Kesari Mahanti for the petitioner the first आरंभ ହେଲା 6686 Mr. Standing counsel for the state Learned counsel for the petitioner refers to the order dated 30/11/2023 wherein at paragraph wherein paragraph पे marking नहीं wherein at paragraph paragraph 2 1 2 3 third subpara paragraph 2 dash third subpara comma page 2 bracket close कर दियो of the order the following was observed the affidavit be filed by 7/12/23 and that defrauded people of an amount of 50 lakhs सिर्फ गोटे पाराटा अछि पेस्ट कर देबे एटी एडा अच्छा आपन आर कंप्यूटर रे अछि पारा refers to affidavit the order dated date wherein the following has been observed quote कर देबे the relevant portion of the order dated 30/11/2023 is quoted herein para The learned counsel for the petitioner submits that upon the instructions of the petitioner, his wife has filed affidavit dated 7/12, dated 6/12/2023, filed on 7/12/2023, which is part of record. In the said affidavit, at paragraph 8, the following has been stated. Quote कर देना para. It is further submitted by the counsel for the petitioner that in view of the affidavit on behalf of the petitioner, paragraph 8 as noted above, the petitioner be shown indulgence as far as prayer for bail is concerned. It is further submitted that the petitioner is in custody since
13/4
dash date okay going to so and so date 38/4/2023 22 na 23 38 sorry
13 for
13.4.2023 the final prosecution report has been submitted on my lord no final prosecution submitted on dash date ta pakhe rakhibe considering the period of incarceration 29/4/23 period of incarceration the petitioner should be shown indulgence. It is further submitted that petitioner is a local resident shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that would be imposed if the petitioner is granted bail. Para. The learned standing counsel. Referring to the materials contained in the case diary submitted furnished by the investigating agency and the nature of allegation. The past affidavit, past achiki.
Yes.
And past allegations of criminal activity against the petitioner opposes the prayer for bail. Subpara. It is further submitted that in view of the affidavit on behalf of the petitioner, particularly paragraph 8, affidavit dated karibe 6/12/2023, suitable conditions can be imposed if the court is inclined to grant bail to the petitioner. Para. Having heard the learned counsel for the petitioner, the learned standing counsel for the state, considering the material on record and the affidavits. The purport line chhad dili. Suitable conditions can be. However, it is not. It is agreed at the bar that final prosecution report has been submitted in the meantime. In the meantime, and
Final prosecution report. Looking.
In the meantime, and the contents of the affidavits indicating past allegations of against the petitioner are in sync with the police report.
Yes.
Having heard, the court is inclined grant to the bail to the petitioner subject affidavits filed on behalf of the petitioner. This court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the Lord Court in season of the matter. The copy of the affidavit dated 6/12/2023 filed on behalf of the petitioner to his wife shall also be produced before the Lord Court in season of the matter to enable the court to consider paragraph 8 of the said affidavit for imposing suitable conditions as would be deemed fit and proper. Amongst other conditions that will be imposed by the Lord Court in season of the matter, there shall be a further condition that any violation of oblique deviation from any of the terms and conditions shall result in case the violation of oblique deviation from any of the terms and conditions shall result in filing a petition for cancellation of bail by the informant oblique victim oblique law enforcement agency disposed of accordingly. सबूतरे सर पारा 8 समान ना अलगा अलगा पैराग्राफ हे गई
समान आगे
नेक्स्ट आगे नंबर कहबे मत
सर अब गोटे कथा आपण पचारले चार्जशीट केबे फाइल जे छाडी थिले जगह
सर हडाइन सर कोइ देसी पहुंची गेलन सर से 3-4 थरा कहलेनी आपण 2 थरा कहलेनी
आज्ञा
आपण 2-3 थरा जो कहले मोर गोटे सेंटेंस कंप्लीट कर परलेन तापरे
राइट सर
सो जोटा इज दैट इज इन सिंक विथ ये सेटा मोर हठात मन पड़ला
सर दीटा को केस रे पैराग्राफ 8 समान अछि सर
चार्जशीट सबुतरे समान अछि डेट
चार्जशीट गोटे कर डेट पाइ
लेट अस गो वन बाय वन नल सेटा भूल हे जिवो अननेसेसरली डोंट मेक इट मिस
सर एटारे
आइटम 13 रे ठीक गला 14 होची 6687 सर
चार्जशीट होची 25/4
6687 आइटम 14 25/4 2023
पारा 8 ठीक अछि
पारा 8 समान अछि
आगे
आ कोटा
आ किछ नै पारा 8 रे टका कथा लिखि छै केते देबी कोन को
yes नहीं any other matter listed today that I was asking
नहीं आगे सेक्टर
allegation सबुतरे अछि सेकंड रेस तो सेम आपण रेस गोटा कर अछि माने आपण तो सीरियल ऑफेंडर हो को जमी पाई पर टका नियंती ना कोन
टका नै नियंती नै थिली
हां आ सब के
टोटल देई पाले नै हाई कोर्ट रो स्टे थिला गोटे केस रे
हाई कोर्ट स्टे कर दे टका जा पे
नै एने केस रो रजिस्ट्रेशन दा
amendment capital हो
और जो कॉल लेने और बोलो कर
15. May I please, my lord?
yes please
My lord, senior is out of station due to health reason. Pray for adjourn.
Mr. R.R. Patnaik for the petitioner. Mr. Standing Counsel for the state. Lord Counsel for the petitioner being present at the it आपनकर कोर्टरूम ना नहीं VC पॉइंट खाली वाजिबो this is not a exact courtroom but maybe it's the Ross Thibo the Lord Counsel for the petitioner being present at the virtual court comma Orissa High Court at comma Koraput at Jaipur addresses arguments. You want accommodation, sir? When do you want? January?
Sir, January 3rd week.
The Lord Counsel for the petitioner seeks accommodation to obtain instruction and advance arguments as paid for list on 25/1/2024 to grant further opportunity to the petitioner The learned standing counsel submits that case diary is available. Yes, next please. Next please. Yes. Yes.
May I please ask?
Yes.
What is last occasion called for the record of status?
Regarding my lord, third person, there is associate, there is no third person perception.
Disposed of Jitla.
Yes.
You are Mr. DJ Sahu.
No, JK Padhi.
Mr. J.K. Padhi.
Yes, my lord.
Mr. J.K. Padhi on behalf of Mr. Amit Bose, 80A.P. Bose for the petitioner.
Yes, surrender certificate. Right?
So read file agent. That is on 16/10/2023. We also filed the surrender certificate. So those things are the
Dismiss it. Though the matter was dismissed by order dated 9/11/2023, Jayanta Kumar Padhi, J.K. Padhi. The learned counsel for the petitioner is present to assist the court. The copy the learned standing counsel referring to the order dated 9/11/2023, last Sapara, submits that he has received information from the INC Belpoda PS District Balangir by DR number 3090 dated 25/11/2023 regarding the threat perception, if any, against the victim, towards the victim and her family.
And the welfare also.
And their welfare. The victim compensation data
that has gone, they will get.
Para. In view of the copy of the said report received from the IAC concerned, produced by the learned standing counsel, is taken on record.
Seithara ache victim compensation.
এটা আপনার চিঠতে চলে এসেছে।
Seithara ache victim compensation.
In view of the report, Para, the matter stands closed. এটা ফিরিয়ে দেবে তাঙ্ক কপি লেটার কপিটা এটা আপন রখিবে yes
May I please, your lordship? Item number 17, I mean VC, your lordship.
Yes.
Lordship, here in the present case,
petitioner.
Here we have been directed.
Yes.
To take instruction regarding the names and proper details of the surety, my lord. That we have not taken. Also, my lord, the criminal incident. Since the petitioner belongs to West Bengal, my lord, we have called for the my lord, the criminal incident from the native police station that has not been received. The lordship may give us some time.
How much?
My lord, lordship may call it after vacation because 302 grams of brown sugar, my lord, huge quantity.
Obviously.
Conscious possession from.
Because I think she's a lady. That is the consideration.
Yes.
The special consideration in case of 302 grams of brown sugar.
Yes.
And today's menace, they're targeting colleges.
Yes, sir. And that is also they are getting use from the, but that police have taken up the investigation yesterday. Our CP, my lord, they came with the press conference and said all those things, and he has taken up the issue.
And after liquor was distributed through Zomato and Swiggy, this is inevitable.
These things are, my lord, very serious.
I mean, if you have a train line, you expect the trains to run over that. Once you have laid a road, you only expect goods train. No passenger trains. Maybe that speed Vande Bharat can run in certain tracks, and that's another thing. Mr. S.K. Jena for the petitioner, Mr. Standing Counsel for the state. Again, this is pending since long. You have not taken any steps. Recently, after prodding by the court, they are taking steps.
Yes, yes.
Relative has agreed to be surety and you have verified. The learned counsel for the petitioner refers to the order dated 15/11/2023 and 29/11/2023 passed by this court. The learned AGA seeks further accommodation to obtain instruction in terms of the said orders as paid for list on 8/1/2024. The instructions as directed be obtained. Yes, next.
May I?
Yes, please.
Item 16.
16 पे कॉल है? Yes, yes, I have noted your presence, Mr. A.P. Bose. Though it is dismissed, but the learned counsel is present to assist the court that I have recorded.
Your Lordship may target the trial.
You talk to Mr. Mahapatra, Diptiranjan Mahapatra. Because I have already one lecture per one topic, not more than one lecture.
No,
So
on that, your Lordship has dismissed.
Today, very detailed discussion with Mr. Mahapatra regarding targeting cases where a person comes to High Court seeking bail.
But here, your Lordship will.
Then you have to include all the persons who are languishing in jail prior to you a party.
No, I'm
you see,
not.
the court is preferring someone. That's a grave injustice.
No, I only pray your Lordship may direct the trial court to expedite the trial.
Expedite the trial in your case, not that no direction in other cases. I can issue direction to, because you see, expediting trial is a target of the High Court in administrative side.
But
that we are doing. But if I find out and point out your case, then I have to pass an order that all cases, or you have to say that this is the only case.
No, I'm not.
And
I cannot say.
And no case prior to you is pending.
No, my lord. Here your Lordship will see.
So it's not a case of no, my lord. It has to be yes, my lord. I'm asking you something positive. How can you answer in negative? Your case is that since no other case is pending, no only trial is pending, but my case is also languishing. I mean,
here the evidence has started. That is the
whatever, sir. That will happen.
But here I'm ready to get married. I have got given interim bail, but still then she is not ready. What can I do? That is my case.
POXO.
No, SC/ST is there.
POXO is targeted because of the statute.
No, I'm just not POXO.
And the conviction rate is abysmally poor.
But here it is.
You must think that what is happening, that could be a correlation. The statute targeting the trial and the abysmal rate of conviction.
My lord may call it some other day or I'll ask.
No, this has been dismissed already. So targeting,
I was granted interim bail by your lordships, but she did not cooperate to marry. The report is there that she is not ready. But should I be put behind custody for this?
For allegations.
Allegation is there.
Not for failing to marry. If semana jodi se dafa lagante tal kohibe. I told you regarding a chief secretary who asked me. I'm sorry, I'm additional chief secretary.
Had married and they were residing outside.
I think he was the counsel for him also for some time. There is a famous case. So on 30, it will be dismissed. On 30/11/2023, the following order was passed when none had appeared for the petitioner, though the matter was called twice over on that date.
Today I'm
the informant was present in person and was heard. Sir, you are making a joke of this CRPC provision. Whenever the informant is appearing,
I have no, my lord. I have no power itself, my lord. Today I am paid for time.
The learned counsel for the petitioner, the learned proxy counsel for the petitioner submits that he has no instructions and he has no power to appear in the case.
Only for the
reasons best known to the learned counsel, he is appearing and seeking accommodation, thinking that it's a liberty to be taken with the court. Don't do that, sir. I'll refer it to the bar council.
I have no any idea, my lord.
So please don't do that. Never do that. Never do that.
Let's pass any other order.
No. I have recorded. I have recorded. You see, you can see it in the YouTube live also.
No,
what you are doing. Sir, when I'm passing an order, you are interjecting. The learned counsel is interjecting when the court is passing an order, saying that it doesn't know anything about the case. be responsible. You are a proxy counsel, you take the responsibility.
Sorry, Your Lordship.
Because you have agreed to your request of your friend.
Sorry, Your Lordship.
Sorry କୁହନ୍ତୁନି. It's a courtroom deliberation. ମୁଁ ତ ଭୁଲ ଠିକ ବାହାର କରିବା ପାଇଁ ବସିନି।
ସେ ଖାଲି କହିଲେ ଟାଇମ୍
ମୋର ସେ ଯୋଗ୍ୟତା ବି ନାହିଁ।
ମୁଁ ଜାଣିନି ମଧ୍ୟ ସେ କଣ ଆଗରୁ
ସେ ଯଦି ଆପଣ କହିଥାନ୍ତେ ଆଜ୍ଞା ଗଲା ଥର
କିଛି
exactly. The learned proxy counsel further submits that he has not been instructed regarding the past order dated 30/11/2023. Yes. On 24/7/2023, after hearing the learned counsel for the petitioner, coordinate bench of this court issued notice directed copy of the petition to be served on the learned counsel for the copy of the petition to be served on the informant oblique victim through the learned court in season of the matter, and to inform them regarding their right of audience in the present proceeding. In terms of କେତେ ସେଟା
430
438
provide you one man. CRPC
439 1 into bracket English 1 into bracket small
439
b proviso. Small b small English b 438 ପରେ 1 ଟା bracket ରହିବ, then small b ଟା bracket ରହିବ, then second proviso. এটা কোন লাগিଛି 376 ab ଦେଖିજો ଯା ବି ତ ସେତେ ତ ଅଛି ସବୁ ଗୁଡାକ
ABDA DB
ହଁ
and 376 3
ପାରା in view of the statute কোন লিখলে in terms of yes. Thereafter on 18/8 none had appeared for the petitioner. None had appeared for the informant, and the matter was further adjourned in presence of the learned counsel for the petitioner. On 1/9/2023, at paragraph 2, the following order was passed. On 4/10/2023, the following order was passed, adjourning the matter at the request of the learned counsel for the petitioner. Again, on 9/11/2023, the matter was adjourned at the instance of the learned counsel for the petitioner. On 30/11/2023, the informant appeared in person. And the following order was passed. The learned counsel for the state also produced a statement of the victim recorded under section 164 of CRPC. Para. In view of the repeated adjournments sought for by the learned counsel for the petitioner, even after the informant, even after the victim appeared by availing the right of audience granted by the statute, 378 it has to be reasonably concluded that the learned counsel for the petitioner has no further oral submissions to make to support the prayer for bail apart from the arguments made in the petition. This court also recorded the statement of the informant when she was present before the court on 30/11/2023. That she opposes the prayer for bail. Court कर दियंतु नि एटा past participle लगला that she opposes the prayer for bail. victim ମୋତେ ବୋଧେ ଭୁଲ ଡାକିଛି informant ସବୁଠି informant କୋଉଠି ପିଟିସନର ବି ଡାକି ଦେଇଛି ବୋଧେ ପିଟିସନର ଆସୁନାହାନ୍ତି victim informant ଆସିଛନ୍ତି yes the submissions of the learned proxy counsel as stated today are noted in detail above. In view of the past repeated adjournments and the submissions of the learned proxy counsel appearing today on behalf of the learned counsel for the petitioner, the matter can't be adjourned any further. Stop. It would not be just and proper to adjourn the matter when the petition is available to be considered, case diary and all relevant materials are produced by the learned counsel for the state directed by the court, and also the informant being heard pursuant to a right of audience as provided in the CRPC. The prayer for adjournment is rejected. Para. The learned counsel for the learned standing counsel referring to the age of the victim, her statement recorded under section 164 CRPC, the materials contained in the case diary, including the medical examination report, ଏଥିରେ ସେ କଣ ସ୍କୁଲ ଆଡମିସନ ଟା ରେଜିଷ୍ଟର କରିଛନ୍ତି ମାନେ ପାଠ ପଢୁ ନଥିବେ ବୋଧେ
No, she left the school. मतलब the students instructor.
ସେ ଯୋଉ I remember that economic ଇଏ ଯାହା and in their ମାନେ they are not encouraged to study also.
Father is not there. Nobody is there to look after. 4 daughters are there.
कौन लिखे
4 sisters.
Recorded under section here. Opposes the prayer for bail. Having considered the pleadings contained in the petition for bring for petition, that is BLAPL, the materials contained in the case diary produced by the learned standing counsel, including the statement of the victim recorded under section 164 CRPC. The submission of the informant as recorded earlier in order dated ette. This court is not inclined to grant bail to the petitioner at this stage. The petition stands dismissed at this stage. Para. When the informant appeared in person on 30/11/2023, she submitted that there is some threat perception towards the informant and her family as well as the victim. Pursuant to the said order, a report of the inspector in charge, Jatani Police Station, Urban Police District, EPD, Bhubaneswar, has been received by DR number 8979, dated 8/12/2023. Copy of the said report is taken on record. As far as the instructions from the concerned police is concerned, are directed by order dated 30/11/2023. The matter stands closed. Para, however, comma. The police is directed to keep a constant vigil and ensure the ensure protection to the informant, victim and their family. The Lord Standing Counsel shall intimate the police regarding the same to do the needful. Yes. এটা কপিটা আপনার মত দেবে কোটে মেস
along with the memo.
Yes. So like a letter along with a memo is taken on record. Obliged. Yes. Yes, next.
19 may I please?
Yes, Mr. Parija. BC Parija for the petitioner.
I submitted to file a miscase on the ground the illness of the mother. As the petitioner could not provide in time, yesterday I have already filed my lord the
Mr. BC Parija for the petitioner, Mr. Standing Counsel for the state. The Lord Counsel for the petitioner submits that IAS kete number kete
1661.
1661 of 2023 has been filed seeking interim bail on behalf of the petitioner. Copy of the said IAS shall be taken on record. Scan copy be updated. Amar kebe file kolegi?
Aji kal.
Filed on date kar diyantu. Aji kete tarikh? 14. 14 filed on 14/12/20 please. Copy of the application is served on the Lord Standing Counsel to enable him to obtain instruction. Detail kisi deina anti.
That is up to the report of July, month of July. No?
Sera kahin korchundi?
Sera paralyzed.
Mane sera kohe kole ଆଉ ଗୋଟେ ଫାଇଲ କରିଦେଲେ ତାଙ୍କର ମାନେ ଏଫଆଇଆର ପୂର୍ବରୁ ବି ଫାଇଲ କରିଦଉଛନ୍ତି.
No matter ସେଟା
ଟିକେ ଗୋଟେ some semblance of respectability ଆଣନ୍ତୁ proceeding ଟାକୁ. We cannot convert into a matter of joke. ଆପଣ ଜୁଲାଇ ମାସରେ ଫାଇଲ କରିବେ ଡିସେମ୍ବରରେ କହିବେ ଏଟା ଅର୍ଜେନ୍ସି ଅଛି. କଣ କରିବେ କେମିତି କରିବେ ସେଟା କଣ ଆମେ ଜଜ ବି କହିବେ ଆପଣଙ୍କୁ ଆସିଷ୍ଟ କରିବେ ଷ୍ଟାଣ୍ଡିଂ କାଉନସିଲ କି କିଏ ଯିଏ ଥିବେ ସେପଟେ ଆସିଷ୍ଟ କରିବେ. That is your discretion, sir. ମାନେ as a lawyer you know these things. How I will pass a order that something happening in July becomes urgent on December 14th
interim bill.
Interim bill. It's a matter of urgency obviously, or something happening sudden, all in a sudden somebody passes away, or something good, marriage. Now the birth of a child has become also a trend. Child birth, tapare ekushya, annaprashanna, birthday.
They
do something, sir. Think be innovative.
uterine paralysis.
अरे तार तो किसी solution नहीं. सेटा आपनको माने मध्य पड़ो कि एटा सेतरे कोन हबो ताले सेटा काहे एटी आउचंदी सेटा कोन मु लिखिबे जे एटा paralysis चिकित्सा हे जो.
I say
you must understand, Mr. Parija, with your age and experience, it is not to be discussed. कौन पे आपण गोटे लिखिबे जुलाई मास जन पैरालिसिस अटैक हेतिला डिसेंबर 14 रे अर्जेंसी आसिला आपण केबेटू जे कस्टडी होले
I'm custody since my lord
12/1/20
कोडियो
well they could have very well this center paper third July you see it becomes still illogical, sir. Then July he should have filed that. July रे paralytic attack hela suppose assuming आपण जुलाई रे फाइल करथांते
सियानी जब बदलला नॉट प्रेस
से फाइल करन तापर नॉट प्रेस करिवे
उन्हें की इंस्ट्रक्शन है जुलाई मास रे
सर्व ऑन द कर स्टॉप कर देबे सर्व ऑन द लॉर्ड स्टैंडिंग काउंसिल सिस्टम ने ऐसे इंस्ट्रक्शन पर असुविधा है जो से स्टॉप द लॉर्ड काउंसिल फॉर द पिटिशनर सबमिट्स दैट एज पर हिज इंस्ट्रक्शंस he may be accommodated to obtain appropriate instruction and he may be accommodated submits that he may be accommodated to obtain appropriate instructions and do the needful and file affidavit, file additional affidavit or IA. अपन गोटे काम करंतु से गोटे additional affidavit IA रे फाइल कर दियो अपन तो रजिस्टर कर देले ताको से बतन ताको नै आसी इंस्ट्रक्शन जे आगे सेंगर 5 वर्ष ला परमिशन रे पड़ी जंदी से आपण कर आई ओब्लिक आए कर दो ठीक है केबे फाइल करिवे आज होला केते 14 केबे अपन तो कर परिवेनी
से घरे एका कहले
घरे एका अपन एटा काई देउतले अपन एटा काई एफिडेविट काई बेकरिया करतले कहले कोडी ଆସୁ 20 ଦେଖିବା ନା ହେଇପାରିବ ସେ କିଛି ହେଇପାରିବ ଲିଷ୍ଟ ଅନ୍ 20 12 20 23 ପ୍ରୋବ୍ଲେମ is your lordship error. Subhash Chandra Sahu for the petitioner. Mr. Standing Counsel for the state. Mr. R.K. Palli for the informant oblique victim. ଆପଣ ପାଖକୁ ପଲେଇ କରି ଦଉଛନ୍ତି PALLI. The learned counsel for the petitioner informant oblique victim being present at the virtual court, High Court of Orissa at Raigada addresses arguments. Yes, what was the last order?
Last order, I has filed it for interim bail. Deposition copy has been already sought to state.
Interim bail copy, Mr. Palli, you have received copy of the interim bail. Please say something. You are not audible, sir. Sorry? They said na. তাহলে 1 pass over କରିକି ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ସେ ଆପଣ ଟିକେ ଫୋନ କରନ୍ତୁ ସେଠି ରାୟଗଡ଼ା just kindly 1 or 2 pass over पर ନବା ସେ ଆସିଲେ yes next
21 kindly taken over after vacation.
Your name, sir?
Devashish Rautray.
So Devashish Rautray for the petitioner, Mr. Standing Counsel for the state. The learned counsel for the petitioner seeks further accommodation to advance arguments. 21.
12 okay.
To grant further opportunity to the petitioner list on 12/1/2024. The standing counsel submits that case diary and he has obtained case diary and the present status of trial and instruction regarding present status of trial is also available. Yes, next. To be called again? Yes.
I have see, 22, 23, 24.
Yes.
Sir, on behalf of Bharat Jali, say, medical case kindly after vacation.
Upon with the sir, upon you are the petitioner's counsel.
My lord, but conducting the case, say, a case of conduct person.
Non-conducting. So all human beings are conduct
case पे से करछंती ओके से पहले से हमरो वन ऑफ द एडवोकेट से हॉस्पिटल रे शांति हॉस्पिटल रे अछंती से टिके
आपण मते दुखबरी कहानी सुनांतु नहीं बट वन थिंग इज वेरी श्योर दैट ऑल ह्यूमन बीइंग्स आर कंडक्टिंग गुड कंडक्टर्स यू विल गेट अ शॉक इफ यू टॉस ए लाइव वेयर
हॉस्पिटल ये काइंडली आफ्टर वेकेशन
the learned Mr. S.K. Barik for the petitioner.
My lord, see that 7436 my lord relating to said affair, my lord, any copy of the order passed it
सेटा अच्छी पे दे रे
लागे relating
सीधा कौन ता संगे तो को का कहार ऑर्डर काहे लागू छी किछ बुझियो नहीं किछ दिन पर that is by this court.
Hello, yeah, yes.
This is by M.S.Sahoo.
Then withdraw, I think withdraw.
Disposed of each into. Second time magile ne? Mr. Dekhle Barik for the petitioner. Item 22, Mr. Standing Counsel for the State. The learned counsel for the petitioner seeks further accommodation to advance arguments. Well, if change कर दियो तो निश्चित तीन power अच्छी तंगर ठीक अच्छी advance arguments.
The file affidavit.
The order dated 26/9. Directing to place on the record the charge sheet has not been complied with. To grant further opportunity to the petitioner, केबे चाहते Mr. Barik?
After vacation.
Second week. Mr. 18/1/2024. 18 January. January 2024 to grant further opportunity to the petitioner.
Charge sheet you have received, let them file the affidavit regarding CM.
It is submit the counsel for the petitioner further submits that we shall obtain instruction regarding the past allegations of criminal activity against the petitioner and file affidavit on his behalf as the petitioner is seeking indulgence of the court for grant of bail. Let the affidavit on behalf of the petitioner indicating the past allegations of criminal activity be filed by 4/1/2024. Copy be served 5/1/2024. Copy be served on the learned counsel for the state to enable him to obtain instruction. Yes.
Item 23.
Same order.
Same order.
Same FIR, Mr.
My lord. 22, 23, 24, my lord.
Hello. Yes, next please.
25.
May please, Your Lordship. My Lord, I mean sub-item BLAPL number 8420/2023.
Yes.
And all are matter connected matter, all are equipped persons.
Yes.
Arrested under section 399 and 402, my lords.
Yes.
Allegation is that, my lords, that on the date of alleged incidents, 5%, my lords.
It is 8420 re sub-item ta lecture apana. Mr. Rashid Kumar Jenna for the petitioner. Itre sub-item re apana ochandi Mr. Naik.
Malad, sub-item malad 8420.
8420.
8420. Item 25 8420. Mr. Devashish Naik AGA for the state. Flag के affidavit टा आपण घर दे दी चंदी.
Again.
से response कौन तारा आस्चिलानी?
It is available, my lord. Perhaps, my lords, they have, my lord.
My lord,
Having
the affidavit, my lord, on being the father of OP number 3, my lord, petition number 3, he has filed petition affidavit for OP number petition number 1
and 2, my lord.
How can
से lecture auntie नल uncle lecture दी. अपन marketing से डा. I am the father of so and so.
Yes.
Uncle of so and so. So all the criminals are related to the person. फिर आप देखो तो कौन तफा कौन लगता है कोड़े कौन करन तो. सेटा कोड़े काली ना पर दिन हम देखते ले. जनकर पिउसी जनकर माउसी जनकर मदर जनकर फादर जनकर मामू जनकर दादू. Okay.
And that report also, my lords, so far the criminal antecedent is concerned, that is also available with my lord.
Exactly. That is how this is required.
My lord.
So आपण ताको चेक करते करथिबे सी चेक करी आपण रेकॉर्ड देखछन्ती ना मिसुन प्रॉब्लम है आपण मल्टीपल करंती एटा कंफ्यूजन हम ही हबो. शेख बसीरुद्दीन में होची को थरे आपण घर बसीरुद्दीन
मोर 3 जन accused.
बसीरुद्दीन
my lord, one is my lord
Ramjani,
Basiruddin,
Ramjani or Akhtar,
and yes, my lord, Ramjani and my lord. So. And in CD it is also available, my lord.
Yes, yes. आपनकर 12 वर्ष आइलानी. You have a career spanning of 12 years. Muhammad Sheikh Basiruddin has a career of 12 years. Ramjan is having a career of 9 years. 9 years. And Akhtar is having a career of
18.
5 years.
In fact, my lord, this is 399. We all are, my lord, congregated in a place and was 319 alcohol, my lord.
ଆପଣ past year ଟାକୁ 18 ମସିହାରୁ ଆପଣ ସବୁବେଳେ କଣ ଯୋଉଠି କଂଗ୍ରିଗେଟ୍ ହୁଅନ୍ତି ଆଲକୋହଲ ପାଇଁ ସେଠି ଆରେଷ୍ଟ ହେଇଯାନ୍ତି? Cannot be.
Because, my lord,
ଆରେ that is the last thing to happen to you. ଆପଣ 18 ମସିହାରୁ କ୍ୟାରିୟର ଆରମ୍ଭ କଲେ, ଜଣେ 11 ରେ ଆରମ୍ଭ କଲେ ଆଉ ଜଣେ से 15 लाख आरंभ कले लास्ट टाइम जेतला आपण कांग्रेगेट कले टू सेलिब्रेट योर कैरियर ना कोन व्हाट वाज द पार्टी
रोसी मद पिउଥିଲେ ବୋଲି
अरे व्हाट वाज द पार्टी व्हाट इज द रीजन फॉर ड्रिंकिंग लिकर they are habitual drunkards or they are celebrating something the career
they are not celebrating their career my lord
obviously
but in fact my lord being
sir you are saying you are falling into the trap as if you are present there and they told you that sir we are not celebrating or they are when they are kind of devdas upset about not being going in the career
ଆଜ୍ଞା
ଯେତେବେଳେ ଆପଣ 14 ଜଣ 17ଟା 18ଟା ଥିବ 8-10 ବର୍ଷ ଆପଣଙ୍କର ଥିବ କ୍ରିମିନାଲ ପ୍ରୋକ୍ଲିଭିଟି you will face don't say anything regarding that how good or how bad you are because you are a proof for yourself
allegation
last time ଆପଣ ମଦ ପିଉଥିଲେ ଆପଣଙ୍କୁ ନେଇଗଲେ कि गंगा जल पिउथले नहीं गले कि एथिरे आपण कहि परन हम पूजा करछु
चार्जशीट से डायरेक्ट कर
ठीक अछि
एंड कस्टडी माइलर स्वामी कस्टडी सिंस माइलर
हाउ टू मेंट योर वेज आपण गिवन टू लोकल सिक्योरिटी और रिलेशन कर आनंतु एफिडेविट
लोकल सिक्योरिटी ये लॉस में डायरेक्ट माइलर फॉर लोकल सिक्योरिटी माइलर
नहीं नहीं सुनतो आपण द बेल ऑर्डर विल बी फ्रस्ट्रेटेड आपणकर थरे वंस आई एम माय सेल्फ नॉट कंसीडर्ड देयर इज अ पर्पस बिहाइंड इट जदि आपण सेठी लोकल सिक्योरिटी देबे हाई कोर्ट रे काई कहबेनी
लोकल सिक्योरिटी नहीं फैमिली मेंबर
सेटा पचर सेटा त कहू लोकल एंड फैमिली बोथ
तांकर जमबाडी भी थिया दरकार
आई डोंट नो you see sir these questions you should not ask the court you should ask your आपणकर आगे आपण जतो से आसी आपण बिल पे आशा नहीं आस्ते अम्लान पाउल एंड जगह आपण तो 19 वर्ष ला कोन 11-12 वर्ष ला कामर अछंती कोथरे बिल आपन मिलछि जे यू विल कंटिन्यू दिस एक्टिविटी अब इथे प्ली नहीं हो जे दे आर फॉरवर्डेड नहीं दे आर फॉरवर्डेड नहीं हो सो यू गेट दैट आपण केबे टू फाइल करले बच्चन तक धरि की
if a lordship will direct for the matter the
if local, he cannot furnish then he has to come back to me that's the problem for him you are not thinking about the petitioner you should be always in the positive not in a negative आपण इंस्ट्रक्शन नियंत आई एम नॉट डायरेक्टिंग दैट आपण जो कहते कोन करबा सेटा तांकु कहि पचारिबे तब दे परिबो कि नहीं लेट देम टेस्ट इट लॉर्डशिप में दे आर सीकिंग इंटेलिजेंस एथे लॉयर कर कोन रोल अछि
लॉर्डशिप में
लॉयर्स आर इवन गोइंग टू द एक्सटेंट ऑफ फाइलिंग एफिडेविट डोंट डू दैट
no we have not
you are अरे आपण कथा हम कहली you are too seasoned or he has become too seasoned also by now
no you don't do that ये लॉर्डशिप में
जैसी करनी वैसी भरनी सर आपण 12 वर्ष ला गोटे क्राइम करछनी तापर कहबे जे हमें मद पिउथुल तो हमें किंतु नहीं गेले ठीक अछि मद पिवा इज नॉट ए क्राइम बट आपण 12 वर्ष का जे तो थिले यू शुड हैव रेस्ट्रेन योरसेल्फ टू गेट टुगेदर तीन जण क्रिमिनल जो एकाटी बसी मद पीबे so police will presume that they are going to do some very pious work can this be a argument no
next week what
astu dekhantu there has to be a family member is a must and a local security nale mu bijoy family member kar diyanti because I know the difficult apun jota just कहले ताकर थिबो कि नै की जानि छै
18
देखंतु आसु आपण देइथिले सेटा वेरीफाई हे पथांत बाय दिस टाइम 18 मिस्टर तले सीरियल लिखंतु हैला तळ पर करंतु भूल वाला ऑर्डर 25 रे लिखंतु फर्स्ट आइटम 8881 Mr. Omlan Shakti Paul for the petitioner, Mr. Standing Counsel for the state, Learned Counsel for the petitioner seeks accommodation to obtain instructions on behalf of the petitioner and file affidavit if so advised in terms of the deliberations today in the court. As prayed for, list on 18 12 20 23. You file the affidavit quickest,
yes ma'am,
so that they can take instruction. Upon after file call, I will get send that for verification. It can be taken up before vacation.
No.
So when a habitual serial offender, how do you grant them bail? Rapon bhabiya katha, mate assist kariya katha. You every case I have to prod you.
they will appear in
अपन जो रेट रे गले अपन किस दिन पर कहबे रोहित शर्मा बैटिंग जाननी. I have to answer. I have to मते से भलिया गोटे ऑर्डर लिखिया पड़ो. अरे you see that you must understand the simile. What logic the court is applying? Sheikh Fariduddin, the most pious of persons, having a career of 11 years, was drinking alcohol only and he was arrested, so he should be granted bail. That is as good as saying Rohit Sharma जानने कोहली सीखी नहीं. ଆଜ୍ଞା 18 ଆଣୁ ଯେ ହବ କଣ ଆପଣ ତ ଦେଇପାରିବେନି 18 ଯଦି ବରଂ ରାଦର ୟୁ ସୁଡ୍ ଫାଇଲ ଦ୍ୟାଟ୍ ବାଇ 22nd survey copy so that I can list it after reopening. Yes, the affidavit be filed as by 20 कर दियो by 20 copy be served. You have a target of 18. Target of 18. List copy be served on the Learned Council for the state to obtain instructions. List on 10/1/2024. Same order in all. खाली appearance टा check करंतु मैं कहि दउ. सित कुमार जेना आउ दुईटा मेटर टोटल ना अछि ना हेला
26.
Please, alerts. On behalf of victim, I kindly taken after vacation, my lord. He has been
name, sir?
Omres Colors.
Mr. A. Colors for the petitioner. On 4/12/2023, after hearing the Learned Counsel for the petitioner, the following order was passed. Petitioner and the Learned AGA for the state, following order was passed. Today, when the matter is taken up, the Learned Counsel for the petitioner seeks a further accommodation to obtain instruction and advance arguments. As prayed for, when do you want, sir?
My lord.
Kebe, चाहूँचोंती.
After vacation.
First, second week kebe, second week, third week.
Second week.
11.
As prayed for, Mr. 11/1/2024 to grant further opportunity to the petitioner. The Learned Standing Council submits that case diary.
Regarding third person, there is no.
See that I have recorded. There is no third person. तापर से अर्जन को यार मकर डले. Case diary is available. Standing Council submits that case diary is available. Yes, next please. Mr. Sahoo.
Obliged. Have you taken up second week of January?
Have you taken permission from Mr. Patnaik?
Yes.
Yes. Mr. J. Sahoo for the petitioner. Mr. Standing Counsel for the state. Counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on second week होले ना? देख दो. The list on 19/1/2024 to grant further opportunity to the petitioner. The Learned Standing Council submits that case diary is available.
Obliged.
Yes, please next.
28.
Ms. Mandakini Ponda for the petitioner.
Lordship, the petitioner has been convicted under section 302. Lordship, last occasion.
Convicted? No, accused.
Sorry, accused.
Accused, yes.
Lordship, last occasion, state obtained instruction.
Yes, say the mental health condition
Lordship.
देखो सेटा कनेक्ट है लगी से जो अच्छा तो ताले हमें तो से काउंसिल अप्लाई कर रहउचंती ना आपन मैटरटा बोधे सेटा कनेक्ट हेलानी सेटा बीटा वाला ना तन कहि दियंतु गोटे टाइम दे दियंतु हैला बीटा वाला आ गोटे मैटर अछि तापर नबा इमीडिएटली गिव यस थैंक यू
That has not come.
Asini, the Learned Counsel for the petitioner refers to the order dated 30/11/2023 to submit that instructions are awaited from the state. The Learned Standing Council seeks further accommodation. How much time, Mr. Standing Council?
Before vacation.
Try करंतु.
Yes.
Accommodation list on 21.
Yes.
List on 21/12/2023 to enable the Standing Council to obtain instruction as directed by order dated 30/11/2023. Yes, next.
29.
Yes, sir.
May I please, madam? On behalf of madam, senior, kindly pass over now.
To be taken, passed over, to be taken, called again at 2 p.m. Yes, next, please.
Obligatory.
Mr. Behra. Mr. Joydeva Behra for the petitioner. Mr. Standing Counsel for the state. Yes.
May I please, madam? Initially, Parvati laws, madam, offense under section, madam, offense 370.
164.
Yeah. Last occasion,
ये rule.
164 statement, madam.
हाँ. इतने नोटिस दरकार नहीं.
2N.
2N. Okay. अरे से आपण तांको बापा मांको बिहेवियर देखंतु मिस्टर बेहरा से झियो को बाडे गोडुचंदी
ना आज्ञा सेमती किछि
किए कहले कोन हो आज्ञा हेटा तो स्टेटमेंट मजिस्ट्रेट लिखले मु तो आज्ञा मोर अथॉरिटी नाही
हजूर गा हजूर
आज्ञा मिस्टर बेहरा कैन आई रिकॉर्ड ए स्टेटमेंट डाकी 164 रिकॉर्ड कर परिबी
नाही नाही
अतले दे आर आल्सो कॉन्स्टिट्यूशनल अथॉरिटी
एनी कंडीशन बा 13 बेट में किछि दउ नै हजूर हमें
आपण को मु देबी छाडीबिनी आपण को बुझी की आसंतु तांको काउंसलिंग करंतु एफिडेविट दियंतु आपण कोन वेलफेयर पे कोन करिवे केते जल्दी करि परिबे काली दे परिबे एफिडेविट काली टेक अप करिवि
नाही आज्ञा हजूर नेक्स्ट वेलफेयर पे कोन
चाहा करिवे आपण तांको बापा से झियो को से जो पुअर बापा मा बाडुचंती गोडुचंती
से कंडीशन हम एफिडेविट से मिलते आउ 13 बेट
नहीं सेटा आपण वेलफेयर कथा कहबे ना थ्रेटनिंग तो मु तांको कहबी स्टैंडिंग काउंसिल से आपण को कोन करिवे आपण बुझतेबे आता हम आपण काउंसिल को आपण सॉरी आपणकर क्लाइंट को
आज्ञा
काली देबे एफिडेविट
नाही मु आज्ञा बलांगिरी मो तांको घर मो दुटा पाटना
तांको घर लोकेशन मु जानि छी पाटनागढ़ तांको घर
नाही मो घर रणपुर आज्ञा
आपण घर तो सेटा मलगा जगह रो जानि छी सेटा सेटा आज्ञा हम घर सेटा नो जे सेटा आपण तांको घरटा आपण आनि की देबे कि जदि कोहंतु ताले छाडी हम छाडीबुनी
ठीक है
कोन कोन आपण करिवे एटा टेस्ट करा जे आपण केस रे आपण बापा मा बेसी उत्पाद होचुन दे
नाही मो बापा मा कोन से कंडीशन को हजूर जा कोई
नहीं नहीं हजूर नहीं दिस इज नॉट द वे टू ट्रीट समबडी सर यू आर स्पॉइल्ड
बोले आज्ञा
गोटे पेरेंट्स कर गोटे किछि गोटे रहिबा दरकार गोटे माने आफ्टर ऑल यू हैव ए सन यू कैन वेरी दे कैन हैव ए डॉटर आल्सो दिस इज द वे यू ट्रीट समबडी
यस मैम
and her statement is very spontaneous
no
the language and all that she is using it is a local language there in Patnagarh
नहीं से आज्ञा से गां मीटिंग
आपण एटा रनपुर भाषा रे कहिथिले ह लाइथांत त कि फेतो सिखैछि ताकू से आज्ञा तांकरी भाषा रे कहछन से
नले
आपण तांकू पूरा तांकू ये करंतु from the parents of the victim regarding no, sorry, it is submitted by the learned counsel for the petitioner that he has instructions from the parents of the petitioner that they will ensure the welfare of the victim and given a chance they shall file an affidavit before this court. In view of such submissions, the matter is adjourned to 20/12/20 affidavit. If so advised, so advised shall be filed. I am not compelling, but that would be your request to the court for seeking indulgence.
गां मीटिंग से रिफ्यूज
गां मीटिंग में this has become a bad thing. Are you are treating the victim as if she has done a crime. It is the other way around. Yesterday, bail application was filed stating that the 15-year-old girl sat on the motorcycle at 4 a.m. and ran away. Then what is the responsibility of the society and the person to take away a 15-year-old girl if she sits on the motorcycle? This attitude has to change. And luckily for you, she is a major.
Major.
Yes. Otherwise, some other offenses would have been abolished and
Law ever since 5 years ago. 5 years ago.
ଆପଣ ଆଜ୍ଞା ସି କହିଛନ୍ତି ସେ ଝିଅ କହିଛି ଆପଣ ତାକୁ ଆପଣଙ୍କ ବାପା ମା ବହୁତ ଇଏ କରୁଛନ୍ତି। So Soumyaranjan Das for the petitioner, Mr. Standing Counsel for the state.
My lord, here in this case, initially the FIR was registered under 307. After being discharged from the hospital, the victim died after 15 days of the occurrence. Now it has must be turned to, for that reason, my lord, directed for up-to-date case diary.
My lord, it has gone to 302. The rejection is on 307, my lord. In the meantime, charge sheet has been filed on 302. Let him, my lord.
Wait, PM report रे कौन अच्छी?
My lord, yes, my lord. Due to cerebral hemorrhage, my lord.
देखे?
Coma due to cerebral hemorrhage.
और discharge कौन इतने कोचें दे अपना?
घर को नहीं गए तक।
That
मैंने आस्ते घर को नहीं गए तापर से
Das you are grossly underestimating others. That's a bad strategy while arguing a case.
The instruction might be obtained from the lower court.
Never do that. Head injury थिला तो आप?
My lord, here.
Pinso साथ head injury रे अपना accused थिला?
आगे. My lord, let him renew his prayer in the court below because he has come against the rejection order.
नहीं, इसे reject ही जान तू. If it chooses to be rejected here by saying that it is a 307 plus discharged, then he died. आपण को कोमा बोली.
नहीं, discharge की जायचिन बोली discharge certificate भी थी बता दे.
Out of those injuries.
FIR injury कौन थिला देखी था?
The confessional statement leading to discovery is there.
Luhar और बाउंसर बांधले. So the cause of death and the injury directly related.
May I pray I may renew my prayer in the lower court again.
Mr. Likle, apparent Likle, the learned counsel for the petitioner submits that affidavit का past allegation affidavit फाइल करछन.
In my lord, no antecedent.
एरा सेठी जा करिवे.
आगे.
The counsel for the petitioner submits that when the BL appeal was filed against the order of rejection of prayer for bail before the learned court in session of the matter dictated.
My lord.
Rejection order dictated था कहीं बाबा की मिसुनिंग और
38/2023 Annex 2 page 30
8/2023 हाँ ठीक है जी. When the petition for bail was moved, it was allegations against the petitioner was under section 307 of the IPC. Thereafter, the injured victim has died, and charge sheet has been filed on.
Charge sheet take filed.
Nine 80.
14/11/2023.
14/11/2023.
Am I?
After the said order. It is therefore submitted that the petitioner may be permitted to move the Learned Court in session of the matter for consideration of his prayer for grant of bail under section 439 of the CRPC. As prayed for, the petition stands disposed of, granting the liberty as prayed for.
I mean the connected matter, same order may be passed.
ଆପଣ ବାଉଁଶ ଧରିଥିଲେ ବୋଲି କହୁଛନ୍ତି?
Yes.
ଆପଣ କହୁନାହାନ୍ତି ସେ ମୁଁ ବାଉଁଶ ଧରିଥିଲି ସେ ଛଡା ଧରିଥିଲେ? Same. Move କରନ୍ତୁ. You are Mr.
M.R. Das.
Second item रे Mr. M.R. Das for the petitioner. Yes, next please.
Happy to
Mr. Please.
Mr. My lord.
No power नहीं अच्छी.
No, my lord.
Mr. Misra for the petitioner. Mr. Standing Counsel for the State, Mr. Amitabh Tripathi for the informant. Yes.
420-294-506. On the last occasion, Lordship has asked me to take instruction with regard to amicable settlement of the dispute. My lord.
Yes.
My lord, and I pray, my lord, Lordship may grant me interim bail subject to condition of
yes, subject to condition of yes, please. Yes.
Depositing some amount because
so that you do. I think he will not object to. No. Object to that.
No, but I am not.
For deposit of money, or he will take the money. I mean, he will accept it that you want or what you want.
Lordship may pass order.
No, I am not direct because I will not enter into the merits. That's a very thin area.
Yes. Lordship may only
so ଆପଣ ଆଇଏଟାରେ କପି ସର୍ଭେ ହେଇଥିଲା
ହଁ କପି ଦେଇକି ସମସ୍ତଙ୍କୁ ଖାଲି ମତେ ଗୋଟେ ମାସ ଆଜ୍ଞା ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦିଅନ୍ତୁ
ଆପଣ 6 weeks ଯାଆନ୍ତୁ ସେଟା ବଡ କଥା ନୁହଁ
and whole matter will be resolved within 6 weeks.
ସେଥିରେ କିଛି କଣ୍ଟ୍ରୋଭର୍ସିଆଲ ଅଛି କି ଇଣ୍ଟରିମ୍ ବେଲ୍ ରେ ଆଭରମେଣ୍ଟ ରେ ନେଗେଟିଭ ତ କିଛି ନଥିବ ଆଉ କଣ?
I am not getting that interim bail application.
ନା ମୁଁ ଦେଇଥିଲି ଆର୍ଥର ଦେଇଥିଲି
ପାଷ୍ଟ ଓଭର ଆପଣ ଦେଖନ୍ତୁ
ଦେବାଶିଷ
it is there.
6 ସପ୍ତାହ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦିଅନ୍ତୁ ଆଜ୍ଞା ପୁରା ମ୍ୟାଟର will be resolved.
For the petitioner,
yes,
Mr. Standing Counsel for the State, Amitabh Tripathi exception. IA लिखिए 1568 of 2023. The IA has been filed seeking bail for a period of 8 weeks.
My lord, I'm sorry. My lord, your lordship must see the instruction.
Okay.
He's saying that you want to, my lord, settle what is the complainant was stated. On the IA, we got the instruction.
She is unwilling to settle the matter. সেটা তো হবো
সেটা বাহারু গলে আগে সেটেলমেন্ট
নেই she is unwilling to yes ସେଇଟା ତ I mean they have wrongly interpreted ଆପଣଙ୍କର ସେଇଟା ତ ହଉଛି ସେଟା ଆପଣଙ୍କର କହୁଛନ୍ତି ଯେ victim କୁ notice କଲେ କହୁଛନ୍ତି ଯେ avoiding appearance
yes
court has issued warrant ସେ ତ ହବ ସେ period of 8 weeks for the ground stated in the petition. Disrupt ହେଇଗଲେ ଫେରେ ପଳେଇବ ଇଏ ଅନ୍ୟ ସେ ଡେରି ହବ the learned counsel for the learned standing counsel has obtained instruction in response to the IA 1568 2023 from the SCP IC Sahidnagar PS Bhubaneswar UPD dated through DR number 5396 14/12/2023 which is kept on record. The said instructions issued from the SCP SCP space IC माने IC माने कौन कहले in charge जो I.C लिखो ना in charge though doesn't give any contrary comments regarding the statements, but indicates that the complainant is not willing to settle the matter outside the purview of the court. ଆପଣ ବି ସେ କହିବେ ତ କଣ?
No, I am not saying matter. I am saying
the counsel for the informant submits that the informant may not have any objections to the prayer for interim bail,
subject to my lord if he will deposit some amount. But to show his bona fideness.
But the petitioner civilian ସେଟା କହୁଛନ୍ତି କି ଆପଣ ଗ୍ରହଣ କରିବେନି ତ ମୁଁ ସେଥିପାଇଁ ପଚାରିଲି the subject to the petitioner depositing some amount to show his bona fide considering the nature of allegation that the petitioner accepted money for providing plot for providing plot for registering plot registering land in the name of the informant. Para. The instructions submitted by the instructions issued from the concerned police through the learned standing counsel is taken on record. Shall be kept on record. Having heard the learned counsel for the petitioner, the learned standing counsel and the learned counsel for the informant, the court is inclined to grant bail to the interim bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter. Stop. Subpara, the court shall also take note of the submissions on behalf of the informant, also not opposed by the learned counsel for the petitioner, that the petitioner may deposit some amount to show his bona fide as far as his commitment towards the informant is concerned regarding providing land for which he has accepted money as alleged. Para. The order of interim bail that would be granted by the learned court in session of the matter shall also contain a condition that any violation of public deviation from any of the terms and conditions that would be imposed shall result in immediate cancellation of the bail order. And the petitioner, the informant oblique victim oblique law enforcement agency shall have the liberty shall file petition for cancellation of bail. The IA stands disposed of accordingly.
One minor small prayer.
The IA stands disposed of accordingly. जो लिखले कौन prayer for bail कौन लिखले नहीं ता पूर्व जोटा है कितने week तक time टा अपन लिखने हैं for a period of 6 weeks.
One small prayer mirror. One
मुझे just complete कर just a second for 6 weeks कर देवे है the petitioners I would condition add करवे that the petitioner shall surrender before the learned court in session of the matter on the period of the completion 6 weeks from the date of release करीवे 6 weeks from the date of release shall surrender before the learned court in session of the matter on the complete period of completion of 6 weeks. Period of completion of interim bail 6 weeks no interim bail. The order to that effect public surrender certificate shall be obtained and published before this court. 6 weeks केबे होची आज हेले
6 weeks हेले से जो दिन तो बाहरी वो दिन तो 6 weeks
बुझिली ना टेंटेटिवली आज केते लागी
जनवरी 2nd week रहेगा ना
आज हेला 14 फेब्रुआरी पड़ेगा ना
February first week.
February 1st week नो
14 एक
February 2nd week.
First week.
3 4 5 फेब्रुआरी 1st week पड़ेगा
2 सप्ताह में
list on 5/2/2026.
One of the surety must be his father or parents.
लिख दियंतु गोटे लिख देबे जे गोटे कंडीशन ऐड करिवे फैमिली मेंबर ऑफ द पिटिशनर शैल बी shall stand surety
And he will not influence or harass the petitioner.
ଶୁଣନ୍ତୁ ସେଗୁଡାକ ସିଏ କରୁଛନ୍ତି
ହଁ ନାଇଁ ସେଇଟା
ସିଏ ଆଜ୍ଞା ଏମିତି ବି କରିଦେଇ ପାରନ୍ତି ଆପଣ 24 ଘଣ୍ଟା ଜେଲରେ କଣ ବସିବେ ସେଟା ଥାନାରେ ବସିବେ ସିଏ ଆସିବେ ମଡିଫିକେସନ ପାଇଁ ସେଥିରେ ଗିଭିଂ କମ୍ପ୍ଲିଟ ଫ୍ରିଡମ ଏଭରିଡେ sit by Mr. Nayak said that please don't it is better to remain in custody.
Chance of hearing during the course of my lord putting
it will be disturbed. So it is only for 6 weeks. Permanent pura bail ହେଇଥିଲେ ସେ 14ଟା condition plus chance of hearing ସେ ରହିଥାନ୍ତି.
One small amount that Lord could decide.
Yes. The opportunity they do
after hearing the information.
So it is that subject to such conditions that लिखले नहीं कि that may be that shall be imposed in the facts and circumstances of the case after hearing the counsel for the petitioner, the prosecution and the informant.
Yes. Obliged.
33.
Yes, 33. 33.
33, my lord, your lordship, kind see the instruction.
Yes.
That orphan affidavit, your lordship.
Mr. Saroj Barik is for the petitioner. K.L. Mahapatra is for the
petitioner.
Also for the petitioner. Informant by no. And our informant by Kamal Lochan, Arabindakya, Padma Lochan even appear Kuchanti. So whenever KL is there, he should not appear for the petitioner. About Kamal Lochan,
My lord.
ଆରେ ଆପଣ ଫଲ୍ସ ଆଫିଡେଭିଟ୍ ଦେଲେଣି କଣ କରାଯିବ ଆପଣଙ୍କ ଯୋଉଟା ସେ ତାଙ୍କର ପାଳିଥିଲେ ସୁପର କଲୋନୀରେ ଆମ୍ମା ନା କଣ ଗୋଟେ
के माला माइनरशिप
ହଁ ଆମ୍ମା ସେ ସମ୍ ମାନେ ସଦର ନେମ୍
as per her instruction the affidavit was filed
କାହିଁ ସେଗୁଡା କରୁଛନ୍ତି ୟୁ ହାଭ୍ ଟୁ ୟୁଜ୍ ୟୋର ଡିସ୍କ୍ରିପସନ ସାର୍
my lords
if sitting here I could understand ଆପଣ କଣ with your experience and age can you not understand
sorry
ସିଏ ଡୋମେଷ୍ଟିକ ଭାୟୋଲେନ୍ସ କରୁଛନ୍ତି ବୁଝିଲେ ଛାଡି ପଳେଇଛନ୍ତି କଣ ସେଟା ଅଛି ଯୋଉ ନଟ୍ ମେଣ୍ଟେନିଂ ପ୍ୟାରେଣ୍ଟସ୍ ଏବେ କାହା ଏଗେନ୍ଷ୍ଟ ଆକ୍ସନ କେ ମାଲା ଏଗେନ୍ଷ୍ଟ ନା କଣ ଲେଟ୍ ଅସ୍ କ୍ଲୋଜ ଦ ଚାପ୍ଟର ଯାଉ ତ recently I have passed a matter where about 25-30% were granted bail in Balasore. One of the accused persons, he pleaded in court that I have a passport, but it's kept in safe deposit locked in a bank. I should be granted bail for obtaining that passport. So these kind of practice doesn't help anyone, and never underestimate the other side. Mr. Saroj Barik and KL Mahapatra for the petitioner, along with KL Mahapatra for the petitioner. Mr. Devasis Naik, AGA for the state. The learned counsel for the petitioner being present at the virtual court, High Court of Orissa. At Balasore, address arguments. On 4/12/2023, the following order was passed. For nothing, a 3-page, 4-page order is being passed. You must understand how much time it requires to analyze your first affidavit, second affidavit. That's the subject matter of 439. Is it not wastage of time?
I'm sorry
No productivity. Sir, don't be sorry. Don't say that. You are wearing a robe. Why should you be sorry? It's a courtroom deliberation. But you must mark the order. The court has to go through everything. It has to be again typed. Takes time. कौन लिख ले? Passed. Pursuant to the said order, the learned AGA produces the instructions from the instructions of the officer in charge, Balasore 1 Excise Station, by DB number 8921, dated 12/12/23. Copy of the said instruction is taken on record. The instruction also, the instruction also contains the statement of the parents of the victim, namely Chandrabhanu Mahakud and Sri Chandrabhanu Mahakud and Sri Chitra Mahakud. Address they dewe, dekhi likhibe, recorded by the officer in charge, Balasore 1 Excise Station. The instruction discloses the following. 1, 2, 3, 4. Height. Para. In view of the above, regarding the categorical finding of the status of the parents of the petitioner, the affidavit filed by one Srimati K. Mala, aged 61 years, so and so, has to be rejected, being has to be rejected, containing wrong statement of fact that the accused is an orphan. इतने कौन आगुरु आपण लॉयर फाइल करथिले कि आपण आगुरु कोन लॉयर्स को एफिडेविट फाइल करथिले प्लीज अप्रिशिएट सर मोस्ट दैट इज द मोस्ट क्रूशियल पार्ट and always the court will not be careful about this. It has a devastating consequence. Just imagine what would happen. कौन लिख ले? The earlier affidavit. ये प्रैक्टिस गुड़ाक छाड़ू आज्ञा प्लीज प्लीज फॉर हेवन सेक जहाँ भी हो आपनकर यू आर यू हैव ऑल वेरी लॉन्ग कैरियर्स एंड for a lawyer who doesn't require when he doesn't retire, but you have to survive to handle your briefs. Don't your profession in such a unceremonious and all these matters. That's not that can't be a preference or a choice for you. आगो एफिडेविट टा कोड़े the other affidavit dated 13/10/2023 filed on behalf of the petitioner also stands rejected. Para. It will record is taken on record. Is what about the bail petition? You want to proceed or you want to adjourn it? Or it shall be rejected?
Adjourn.
The lawyer counsel for the petitioner seeks accommodation. Tapare BL appeal it got interim bail re jai chante na main no. I will. The lawyer counsel for the petitioner seeks accommodation to advance arguments regarding the prayer for bail as prayed for. Kebe chahunchନ୍ତି? January first week, second week, third week.
First week.
As prayed for list on third week date कर दियंतु.
24.
थर्ड वीक रे फोर्थ वीक चढ़ाई जो थर्ड वीक ले 16 रु 19 4 दिन अछि लिस्ट ऑन 17 20 24
17 minutes.
17 case diary is available. The learned AGA submits that case diary is available. Maybe Mr. Naik, he's facing difficulty because though he's not upfront, he's not in with his family.
That is true.
That aspect has to be considered.
They have not been in touch. He has not been in touch with his
for 5 years.
5 years now.
So perhaps the condition to file the affidavit is not working in his, somewhat has become too much rigorous for him. He would find out somebody who can file that affidavit with proper instruction. So the problem is that when you are venturing into this, you lose credibility. When the petitioner, and this is maybe not the advice of the petitioner, this is a advice, obviously not advice of the petitioner, he doesn't understand all these things.
His wife is there.
Yes, Mr. Standing Counsel says he is married and...
No, but then wife is also residing with the in-laws.
Yes.
So
he has left home.
He has left home. Correct, my lord.
And Jajpur is a nearby place to Keonjhar. So he has left home, staying at Jajpur. And, yes, next.
34.
Recalled again. Yes, next, please.
35.
Yes.
My lord.
Dr. Simanchala Ranjit for the petitioner, Dr. S. Ranjit for the petitioner, Mr. S.S. Kanungo AGA for the state. Local area was he's outsider.
We have filed the affidavit.
He's an outsider.
Yes. And outside.
ସେ ଲୋକାଲ ଏରିଆରୁ କରା ସେଠିକାର ଇଏ ଆଜ୍ଞା ସେ କୋଉଠିକା ଲୋକ?
ସେ ଉତ୍ତର ପ୍ରଦେଶ.
ଉତ୍ତରପ୍ରଦେଶ.
And last time SP Gajpati was
requested to get it from the SP local area.
Verification.
Yes, that I was asking you, sir. That instruction has not come. Order is Ranjit for the petitioner, Mr. S.S. Kanungu for the state, Learned Council for the petitioner refers to the earlier order dated 17/11/2023. Para. The Learned AGS seeks further accommodation to obtain instructions in terms of the said order. Para. Let the instructions be obtained by दस एक कोड़े 24 list on 16 you have a target of also try to get it prior to that. I'll do that. Yes, obviously. I mean, I'll do that. I know. I'll do. But at times, I mean, your office also doesn't realize the right letters. Yes.
No. 17/11/2023 order has been communicated to the country already.
So that by 5 it was done on by 5 January 20 again by 5 January 5/1/2024 list on 10/1/2024.
My lord. Item number 36 is the same.
Outsider.
Same FIR.
FIR, but he's also an outsider. He's also because you see the local area they don't respond.
My lord.
Today I was telling you. Beyond that I cannot say they don't respond. Yes, next please. Yes, please. M.K. Swang कोड़े वाले. To be called again कर दियो तो M.K. Swang अच्छा थी की. Rest of the matters after recess. You are mentioning something, Mr. Misra?
My lord, item 42 I pray for adjournment due to 4-2, my lord. That's the modification application.
February na January केबे चाहुछन्ती?
My lord, first week of January.
First week रखन्तनी बहुत गुडे मैटर रह गलानी. 42 तो मोर हो. That
My lord,
42 रे गोटे डेट कर दियंतु. This because of some specific reason. Yes, just kindly see Mr. Pratap. Again, same problem. You are not looking at the court. You are engrossed in your work. मुख्य काम है मतलब अन्य लोगों को चाहूँगी देखिएगा. And Mr. Pratap, you go to this side. Hey, Mr. Barik, go this way. Let Mr. Rautra also see because. Yes. Just see that page 8 top, that blue flag. Just kindly read that. Your left hand, you are just page 8. Yes. Just read that in the microphone so that I can also hear.
Government in School and Mass Education Department had constituted a committee headed by State Project Director OPEPA, right? Government Office Order number so and so dated 14/11/2008 to examine the viability of private managed primary schools to declare as project primary school and furnish their recommendation to government for consideration of the proposal. Recently, pursuant to the order of the Hon'Ble High Court dated 19/11/2007 in OJC number so and so, as per the recommendation of the committee,
the recommendation of the committee? Yes.
As per the recommendation of the committee, once Somagiri private managed primary school has been taken as project primary school under SSA.
Because I could not, I had no choice than to again to rehear the matter. So the story starts there. So where is that committee report, formation of that committee? I have searched each page of the file. And Mr. Sakti Sekhar, I mean, in the brief, Mr. Rautra, I mean, your instructing counsel also must know that perhaps they also missed it. I could not find in your brief. I have searched the entire brief, that records. But I'm not sure because it is in some 500 or 600 pages, but I have tried my best. So now, so both of you kindly see this. Then your work I have done. So please, again, upon the same problem. You are disoriented. Sir, you are not watching the court proceeding. You are much below the level and you are not doing anything. Dita copy, sir, achi? So both of you please have the copy separately and read it. Yeah, Dita copy, sir. Just kindly mark order number 2218. Dated 14/11/2008. So the story starts there. Yes. The entire factual background is that.
Will you not 1 minute per minute? So, my yours is correct. So, you have occasion to go through the entire note sheet.
No, I could not get it, sir. My difficulty was that, yes, though it starts there, so yes, the reason could be that this is a committee for the constituted in general to consider all such cases.
Right, sir.
And now you find that report of that committee, yes, which you haven't. That report of the committee.
Yes. That is that at page. That is at page 71. Page 71. Subsequent to that.
Sorry,
and if you also look
more of brief ta semane you karna hanti. Apna 71 question.
Page 71 dekhon. Sir, more is a very limited question.
No, sir. I have noted your points. Yes. That is not difficult.
No, sir. In
71, let me check whether that is the committee report. The committee report is there in the record.
Yes, sir.
That
this committee, when it was constituted, I don't know. But this committee,
no, Mr. Rautra, it has some other significance. Because that committee is formulated found by the order of the government.
By government, yes. Which your lordship is referring to. That is way back on 14/11/2008. Now that
committee is yet to be abandoned or yet to be disbanded. Sir, and the other difficult part is that,
yes, sir,
that committee has been formed specifically for that purpose.
May not be for the purpose of this present school. But you actually
no, sir, in general. No. So then, sir, you have to mark that language. Page 8 dekhontu. Page 8. Yes. Language 8 mein dekhontu.
Sir, 8 mein dekhontu. Page 71.
Private managed primary schools.
Sir.
Viability of private managed primary schools to declare as project primary school, and just see page 8 again of that the notes part of the government record.
Government record of the notes sheet.
It says this is the committee pursuant to an earlier order by the High Court in a particular OJC.
Right.
So the number and the date matches.
Number and date match. No case again match couldn't.
That's the only difficulty, my lord, this, and I seek instructions on this if it's necessary.
No.
At page 71.
So 71 is that. Match karunu Upon case match karuchi. That committee has considered the case of your case pursuant to the direction or otherwise. That's another thing. But that committee is a government statutory committee formed by the government.
Yes. A meeting of the committee constituted by government order number dated 27/7/2011
to decide the claim of the petitioner in pursuant to the order dated 22/2009 passed in WPC number 17411 of 2008 in the case of the petitioner.
No, Mr. Rautre. The committee remains the same actually. Sit out there पढ़ंतु. आपनकर page 8 just kindly look at page 8 again.
So देखिए
छाड़ दियंतु. Page 8 देखंतु. Page 8 whether it matches or not that later.
To examine, so the Lordship at page 8, it says government in school and mass department had constituted a committee headed by state project director. Wide government order.
Order number?
Wide government office order number 2218 dated 14/11/2008.
Yes.
To examine the viability of private managed primary schools.
Yes.
To declare as project primary school.
Yes.
And furnish their recommendation to government for consideration of the proposal.
Yes.
Recently, pursuant to the orders of the Hon'Ble High Court dated 19/11/2007 in OJC number 3846 of 2000, as per the recommendation of the committee, one Somagiri private managed primary school has been taken as project primary school under SSA since there is no nearby school within a distance of 1 kilometer of the said school, and decided to treat the regular qualified teachers of the school as Shiksha Sahayak under Sarv Shiksha Abhiyan from the date of the issue of the order. If considered pursuant to the orders of the Hon'Ble High Court in the present case, that is Shikhar Chandi UPME school, the claim of the petitioner be examined by the committee constituted by government with a office order number 2218 dated 14/1/2008 regarding viability of the school in question to declare as project school. My lord, so the last paragraph actually says that this same committee is going to...
So that 8 you can find, I have marked, all flag marks are there. That is again referred again. And here, just mark what now 71. 71 and this 2218. 71 what Mr. Rautra is... 1, 2, 3, 4. Did you mark in 71?
Page 71, my lord.
Page 71. Just mark the left side and the notification left side. It is the same committee.
Yes.
Project director, then additional secretary, then deputy director, finance, deputy secretary, and deputy director, elementary education.
Obliged.
So in fact, that committee has recommended.
My lords.
And so no, Mr. Rautra and Mr. Pratap, both of you, if you want to address on this, so no, initially, please, I may be permitted to say what happened. I was thinking that I did not bring it, but then I realized that somehow neither you have referred to, then you have to refer. So then it has to be,
I'll refer to this and
so what only request the earliest.
Even up, you have to keep it to Monday. Monday or Tuesday.
Yes, you take.
Yes. My lords, yes.
Yes.
Publish.
Or at the most, because this
sorry, Joe, it will be
because what has happened that it requires substantial time also.
My lords.
Because and now you should take back the records also, because now since you are referring to it, I have to give you back the record. That's the other part of it.
Take the records.
And I have flag marked both the twice because they are saying there are 2 orders by the committee. 2 recommendations by the committee, and this committee is not for this Shikhar Chandi specific.
My lords.
Somagiri, and subsequently they have been assigned that duty.
My lords.
And that is the genesis of this entire controversy.
Sir, more entire case to be mentioned, just so far the question of law is concerned, the government has already taken a decision. That
I understand, sir.
And not only taken a decision.
Sir, the problem is because the issue I have to again answer that. Because to answer that, this committee, this is again a government order.
No, sir.
This has been yet to recalled, or it has to be interpreted.
I am requesting also my landframe, the page 71, that committee has been constituted by the government.
Yes, sir. No. Sir, this same order.
Same order.
Project director Upepa, additional secretary. Yes. Say how I could guess when I know this, because tried to go through the entire file. Several times this I have noted page 8, then page I think I have marked flag marked also. You just find that reference to this committee and report of this committee in the what is that called? Communication side. This is notes.
Yes, ma'am.
On the other side, this report is there again. This committee report is there. That is how I try to understand that whether this committee refers to and what the note as at page 8 of the notes.
Yes, ma'am.
Is exactly is correct.
So that corroborates, as your lordship said. That
basically that so this is a committee formed for this purpose, this particular purpose in general. It's not in the law. If you call it is in REM.
So I request my lord friend at least not to make further confusion. At least
no, sir. Now only for this thing because because it is a public document.
Right.
But I can say the only difficulty would be that none of you refer to because I then searched in the entire records. Here it is not there. And
my only short submission, my lordship, is that nothing. I will get instructions, but not much turns on the nature of this committee because my submission is that pursuant to this committee's recommendation.
Now you can go back. Now you can't go back. Because your entire submission has to be tested.
Yes.
Whether this committee's recommendation was acted upon or not. That's the thing. Apart from answering your propositions,
my lord.
And the second part, since you are saying that, so I am telling you. You just examine Schedule 1 and Schedule 2 of the Government of Odisha Rules of Business.
My lords, my written note is also on that.
Yes, you are specified.
My lords.
But it is to be the Schedule 2 is to be referred to the cabinet. It is very specific.
My lords, I shall look into that.
Yes, you also like anyway. That's your argument. So that
can you give me 2 to 3 days because the relay of information may take me some time. It's a weekend.
Wednesday. Anyway, but I think no further arguments on this.
Yes, unnecessary.
Because once you produce that records, I take notice of those records you have produced. There is this 22218 of 14/11/2008 that committee formed by the government is there. Then I have to also to answer that.
My lord, my only submission, my only request would be
the petitioner's contention also doesn't change.
My lord, I'm not at all changing my stance.
No, you are not changing. You are not changing your stand, but it has added the dimension of that.
My lords,
because this recommendation is of that committee only, and that because that is their content at several times, several places in that records.
My lords.
The matter was finally heard on 14/9/2023 and judgment was reserved to be pronounced.
Permit me to...
Yes, please. Yes. The judgment was pronounced. The judgment was reserved to be pronounced on perusal of the records, particularly the records for the original records of the government produced by the Additional Standing Council. Indicates that at several places. Please just give that record. I'll return it. Yes. Make a assumption. Upon vision that John record name sufficient. Boss John it bosile सुविधा है. लिख ले. At page 6 of the notes of the file 1-SME-capital all caps Roman 1-SME-G-98/12 तापर लिखिबे ब्रैकेट 41/14 indicates the following. एटा अपन टाइप देखि लिख देबे बेटर होना भूलभाल पेज 8 रो पारा 8 लिखिबे जो 6 लाइन अछि ହେଲା. In view of the above, the entire records of the entire pleadings of both the parties to the litigation were examined to find out whether the said office order number 22, Government of Odisha, School and Mass Education Department, office order number 22218, dated 14/11/2008, has been referred to. Somehow, it is referred to, and for the seeking a further clarification, the matter is listed today the learned counsel for the petitioner as well as the learned senior counsel for the petitioner as well as the learned ASC seek further accommodation to take specific instruction regarding the said letter and argument पे तो रखी होनी and provide instruction if any before the matter can be again taken up for judgment. As prayed for list on 20/12/23 at 2 p.m. When the matter will be taken up on 2 p.m. Again, the original records as requested by the learned AC, since he requires to refer to the original records, the records shall be handed over to the learned AC to enable him to go through the same and obtain instructions. The copies of the order. Anyway, I'm not referring to any copies because none of you have. Now I will take note of that. ଆପଣ ଏବେ ତାଙ୍କୁ ଦେବେ ନାହିଁ ସେଟା ସେଠି ରଖନ୍ତୁ ଆପଣ ଅର୍ଡରଟା ଶୁଣୁନାହାନ୍ତି ସେଟା ପରେ ଦେବେ ସେ ଆପଣ ଟିକେ ରଖିଦେବେ ମିଷ୍ଟର ମହାପାତ୍ର you receive the records letter after it is the order is I'm going to କରିକି ନେଇ ଆସନ୍ତୁ ତାକୁ ପଠାନ୍ତୁ ବାଇଲେ. Yes, no, Mr. Shakti Shekhar, why I pointed out, I was referring you that you must have researched on this. Both of you, Mr. Pratap also. Because once you see that it is being, genesis is that committee has considered, then whether that committee is there, whether it was notified or not, that you have to verify.
My lords. Whereas one request, my lordship, may only refer to 2 documents where all my submissions are encapsulated.
No.
Because I may not have been very clear in my oral arguments.
No, not at all. Not at all. Even after a long time, only the surviving memory is the written documents.
My lords.
Yes.
And my additional affidavit as well.
Everything.
Obliged, my lords.
Everything. Because your stand is somewhat very clear to the extent that it conferred no right. But the problem is that now it has to be answered that whether
I fully understand.
That
genesis of
that genesis can
because at the end of the day, lordship has to also say factual things before coming to the dispute, which requires clarification.
Yes.
My lords,
and in this case, the second order recalling doesn't refer to anything. That is the most difficult part of it.
My lords,
the reasons for recalling the earlier order doesn't disclose anything.
My lords,
what was the consideration? And the earlier two orders considered what?
The earlier 2 orders, whether this is to be taken over.
The earlier order considered. The earlier 2 orders considered the recommendation of this committee.
My lords, yes.
So that I wanted to tell you.
And then it was reconstituted and reactivated.
But why I did not want to list it again? But because I substantially progressed in analyzing the whole thing.
My lords.
Then when I stopped I could not get that record actually. I could not get you for just search in your record, it is not there. So I have found it out. Yes.
Obliged.
And the copies from the authentic source, no problem. Yes.
Item 11.
Yes.
Maybe.
Yes.
It's a case under 20B2C of NDPS Act.
Yes. Mr. Amlan Shakti Paul for the petitioner. Mr. S.S. Mahapatra. AC for the state. से ऑर्डर टाको टाइप कर दियंतु आपण पर जे आसे तपर रेकॉर्ड टाको भी कर देबे गोटे ऑर्डर कॉपी दे भी
Lord, as per direction, my lord, I have filed a affidavit of the informant's brother, my lord, that the present petitioner's brother, my lord, that the present petitioner has no criminal antecedent. And there are
just a second. That matches with your instruction from the.
Yes, my lord. No, but that doesn't match, my lord. I have received the instruction. He is having one criminal antecedent.
apart from this?
Yes, ma'am.
Number time is to?
Yes, ma'am. He has to file further affidavit on this.
No, there is no payment.
Para 2 is not correct, Mr. Paul.
Yes,
yes, ma'am. PS case
Mr.
number
Mr.
is being implicated.
Sorry, any confusion?
लिखी नहीं अंत
मेमो सांगे जोड़ा चल 8 नंबर अपन नंबर पके देबे
apart from this, my lord, he is being implicated in Mohana PS case number 144 of 2019.
CCTNS data thibo CCTNS data रे थाई परे
No, no, my lord, Mohana PS specifically intimated to the excise inspector. So,
Amlan Shakti Paul for the petition देखिए appearance. The learned counsel for the petitioner seeks accommodation to file a further affidavit. In supplementing the affidavit dated 23/11/2023 filed on behalf of the petitioner through his brother regarding past allegations of the allegations against the petitioner as far as criminal activity is concerned. How much time, sir? कितना समय लगेगा फाइल करोगे?
My lord, I will file after vacation. Let it come.
Affidavit by माने January में 22nd December ना किबे करी?
22nd December.
Affidavit will file as prayed for. Affidavit will file back by 22/12/20 23 January केबे चाहुछंती?
January second week.
List on 18/1/2024 to grant further opportunity to the petitioner. The learned AAC submits that questionnaire is available and he has also received a response in the he has also received response to the affidavit filed on behalf of the petitioner.
As per my instruction, in this case, my lord, there are two petitioners, my lord. And my instruction is that against the present petitioner, there is no antecedent.
No, no, मिसे दियो जो बहुत असुविधा हो.
हम मिसे नहीं, मु आगे.
ଆପଣ ଦି ଜଣ ଫାଇଲ କରୁନାହାନ୍ତି. ଅସୁବିଧା ହେଇଛି କହିଲେ.
ଜଣଙ୍କର ଫାଇଲ କରିଛି.
ଜଣଙ୍କର ଫାଇଲ କରିଛି. ଆପଣ ଆକ୍ଟିଭ ଦି ଜଣ ଅଛନ୍ତି.
ଆଜ୍ଞା.
ଚାଲ ଠିକ ଅଛି. ନା ନା I thought that ଆପଣ ଦି ଜଣ
the present petitioner.
No, I got that. So ସେତେ ଭୁଲ କାହିଁକି ହବ? ଆପଣ ଆଉ ଚେକ୍ କରିଦେବେ. ସେ କହିବେ ଯେ ଦୁଇଟା ଆକ୍ୟୁଜ ଅଛନ୍ତି, ଗୋଟେ ଆକ୍ୟୁଜ ର ଅଛି ଆଉ ଗୋଟେ ଆକ୍ୟୁଜ ର ନାହିଁ.
Yes.
Just check it.
देखो 5 item 20.
Mr. Palli, can you hear now? Yes. This is for interim bail. Interim bail, do you have any reservations? Any instruction from the informant victim?
No.
No, usually they should not have. Mr. Subhash Chandra, acha, upon instruction aschi?
My lord, instruction regarding interim bill I have not received, but the PW4, the victim has been examined as PW4, man.
PW 7 and 11. 7 is the informant, 11 is the 7-11 mati deina di copy to
7-11.
Mr. Subhash Chandra Sahu, asu. এটা ଆପଣ ନେଇ ଯାন
7-11 মত তো কপি দেয়
দিয়েছি প্রিভিয়াস ডেট রে দিয়েছি প্রিভিয়াস ডেট রে দিয়েছি
হ্যাঁ
11 is the victim and
yes sorry I am not PW7
देखिए ये फिक्साटा उठेन बारीक से फिता बांधी रेकर्ड को बांधी पारे ओरिजिनल ठीक ठाक से कहले नहीं जीव दिस इज आइटम केते आइटम कोंतु 20 Mr. Subhash Chandra Sahu for the petitioner, Mr. Standing Counsel for the state, Mr. R.K. Palli for the informant, public victim, Learned Counsel for the informant, public victim, engaged through legal aid, being present at the virtual court, High Court of Orissa at Rayagada, addresses arguments. I will tell you, IN number 1650 of 2023. Yes, upon a quota cothile
PW 7 and 11. 11 is the victim, my lord.
7 and 11.
11 is the victim.
Okay.
Victim stated that I stayed with him in his house for 3 years. Thereafter, the accused told me to leave him, saying that he has no interest on me. I refused to leave his house, but the accused
ମାନେ ଏଥିରେ ଫର୍ମାଲ ମ୍ୟାରେଜ ହେଇନାହିଁ
ତାଙ୍କର ଜାତି ପ୍ରଥା ଅନୁସାରେ ହେଇଛି। 3 ବର୍ଷ ରହିଲା ପରେ ସେ ଯେତେବେଳେ
ପୋକ୍ସୋ କେସ୍
କହିଲା ପଳା ବୋଲେ ସେ ଘରକୁ ପଳେଇଲା। I stayed in his house for a period of 3 years and we both
The outsider na insider?
Inside. It's from the jail itself.
এটা interim bail ପାଇଁ ଚାହୁଁଛନ୍ତି?
Interim bail.
ତ ଭଲ ହବନି।
That short period.
Cervical spondylosis କଣ ଭଲ ହବନି? But anyway, but I mean your plea is genuine. That's the short point. IAA लिखिବେ 1219 of 2023. ଆପଣଙ୍କର একটা କପି ଅଛି ଆଉ ଗୋଟେ ଦେବେ କପି।
ମୁଁ ଗୋଟେ କପି ଦେଇଦେବି। I'll give a copy.
Mr. Prakash Chandra Das for the Prakash Chandra Das for the petitioner, Mr. Devashish Naik AGA for the state. The learned counsel for the petitioner IA लिखिबे 1219 of 2023. Dated the learned counsel for the petitioners refers to the order dated 14/4/12/2023, whereby whereby it was directed to obtain instructions in response to the IA filed by the petitioner for praying for interim bail. How much time you have prayed, sir?
6 months.
6 months କିଛି ଲାଭ ହବନି। 3 months ପାଇଁ ଯାଆନ୍ତୁ। Because ଆପଣଙ୍କର से एमआरआई कर तो करेगा जानले केमते एमआरआई करछन किछ तो लिखुनांती एमआरआई डायग्नोसिस केमते हला और इट इज जस्ट ए
para 3 रे एक्चुअली
para 3 एमआरआई लिखछंती
हां
आपण लिखछंती नहीं सो मु सेटा पछन मु मिस्टर नायक को पछरथिल जे ता रेफरेंस किछि नाही ना रेफरेंस अछि ना एडवाइस अछि किछि डायग्नोसिस किछि लिखा है। So then it becomes what so vulnerable and I mean what a matter of controversy. अच्छी ଆପଣଙ୍କର ଗୋଟେ
this is page 7 ନେମ୍ ଦେଇଛି
Annexure A1 series page 5
to 6
ଆପଣ ଦେଖନ୍ତୁ ଆପଣଙ୍କର 22/2/20 ରେ कंडीशन थिला तापर आपण डिसाइड कले मोर स्पॉन्डिलाइटिस हे गलानी मु एथरा गंजे व्यापार करे सो दैट आई कैन गेट इंटरिम बेल बुझपारछंती कि दैट कैन बी द ओनली इंटरप्रिटेशन देखो 20 मसेरे आपण देखନ୍ତୁ C3 C4 C6 C7 diffuse disc bulge and central annular fissure ये कंडीशन पर आपण काई डिसाइड कले अपन तो कॉन्शियस पोजीशन दरकार 3 क्विंटल पिठरे उठेବାକୁ पड़ियो 2 क्विंटल 1 क्विंटल
I was implicated my
sorry
well I was implicated in the main bail application I'll satisfy my
no the question is that whether actually though I am granting bail but whether this can be a ground. To my understanding, this cannot be a ground because you have chosen that after falling ill, somebody after falling ill decides to do a crime. Say after being diagnosed with terminal illness of cancer, he kills somebody. Then, what is a good ground for granting interim bail?
Not good, but
because somebody so I mean by destiny, he is already facing so much, and he still decides to do something. Then
He has got 4 criminal antecedents, so
Yes.
he has been a carrier.
कौन लिख ले? The learned AG has received instructions from the medical officer Subjail Nayagada addressed to the superintendent Nayagada district jail, Nayagada sub jail, indicating the following. He has been diagnosed to Neki oriented पर्यंत. Present health status is conscious, afebrile, oriented. Para. Considering the submissions of the petitioner, taking a sympathetic view, the court grants interim bail for a period of for 2 months. दियंतु देखिबा कि आपनकर for a period of 2 months from the date of release from custody, subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter. We shall also include the following. We shall also include the conditions. Then subpara kariki, there shall be 2 sureties for releasing the petitioner on interim bail, one of whom shall be a family member. Then other conditions should have likhibe. तापर लिखिबे जे that any violation of deviation from any of the terms and conditions shall result in filing a petition for cancellation of bail by the law enforcement agency, disposed of accordingly. The BLAPL shall be listed on 14 December है ना? ताले हबो 13 January, then 13 February. Listed on 19/2/2024. The petitioner shall surrender on period of completion of the interim bail before the court in season of the matter. The surrender certificate /order indicating the petitioners submitting to the custody shall be produced and filed before this court. Yes.
Item 34. On behalf of Mr. Bahadur, can you taken up next thing, Mr.
Sahoo.
Yes.
Mr. S.K. Sahoo, you are
Mr. S.C. Sahoo, Subhash Chandra sir.
I'm sorry, S.C. Sahoo, on behalf of S. Bahadur for the petitioner. Mr. Standing Counsel for the State. Counsel for the petitioner seeks further accommodation to advance arguments as paid for 21, sir.
Next week in date.
But now let come out of the depositions.
Accommodation to no, say 6 accommodation to advance arguments. The learned standing counsel in response submits that case diary is available. Trial has already commenced. The learned counsel for the petitioner should make an endeavor to go through the statements of the PWs, provide the copies of the same for consideration of this court. The learned counsel for the petitioner submits that he shall obtain copies of the depositions of the PWs examined till date, provide the copy of the same to the learned standing counsel for the state, and I shall also file the same before the court. As paid for list on 2nd week of January.
Yes, ma'am.
11/1/2024 to grant further opportunity to the petitioner. Yes, next.
37.
Item 37, I pray, can it taken up?
Mr. N.K. Swine for the petitioner. You are not there when the matter was called. I thought you were present.
Another.
Maybe I saw you earlier, maybe that. N.K. Swine for the petitioner, Mr. Standing Counsel for the state. Counsel for the petitioner seeks further accommodation to advance arguments as prayed for list on
January
2 week sir.
January
Second week. 18/1/2024 to grant further opportunity to the petitioner. The learned standing counsel submits that case diary is available. Upon allegations किछि नहीं. अपन जनवरी जाए पकेलेनी आकु पके माने जनवरी मासरे पिटिशन डिसेंबर मासरे अपन एफिडेविट फाइल हेनी. अपन कथा जनवरी में कहूनी मु देखिनी. आई एम टॉकिंग अबाउट द ट्रेंड. यस.
Item 38.
Case diary is available. लिख लेता. Yes. Yes. Next. 30 पर मेंशन करें. It Mr. Naik को दे देवे. Mr. Naik, you provide a copy of this medical report. वर्तमान रिक्रुटमेंट हेला कले बेमारी लोकन को रिक्रुटमेंट करा होची एथि पई. बेमारी लोक जे हेतु पैरालिसिस तो अने देखले.
ओ ठीक सी बात.
ताले तो तबरे बेल फाइल हबो. आ ये तो केबे भी भलो होबनी. 20 मसिर तो बहुत इम्पॉसिबल माने. Yes, sir. You provide a copy of that. Yes.
38.
38 गुड़ा मेंशन करथिले. देखुछ. Mr. खगेश्वर बेहरा. On behalf of Honorable Das for the petitioner, Mr. Standing Counsel for the state, Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions and advance arguments as per for list on PC 2/2024.
39.
Rajendra Narayan Raut for the Mr. Ronak Raut, Mr. Ronak R. Raut on behalf of R.N. Raut for the petitioner. Same order, list on 3/2024. Mr. Standing Counsel for the yes.
40.
April 40 and 41. Both the petitions.
40 somebody is appearing. Can you just serve another copy?
May I submit notes, sir?
Yes, please.
Item number 48, 41 pertains to the year 2018.
Oh, 18. But since I think in 40, I think somebody has appeared and let me check the order sheet. No, why there is a noting SK Ponda, K Ponda? It was taken up earlier because the noting says for final order in condonation.
No, after that, both the matters 40, 41 after application.
On 3011, notices were issued on limitation. That is how it has been listed for final orders. 40 Mr. S. Das, Sangram Das, Standing Counsel for the state, opposite party blank. The Learned Counsel for the petitioner seeks accommodation to advance further arguments. And I hear order karibe. As spread for list on after application. It will go to February because these matters are not right.
28.
28/2 28/2/2024.
The same order maybe
41 same date or on other date? Same date, 41 same order. I hear it.
42.
Mr. R.R. Misra for the petitioner. Mr. Standing Counsel for the state. IA 471/23. The disposed of matter, good idea. The Learned Counsel for the petitioner seeks accommodation to advance arguments as paid for list on 17/1/24.
43.
Instruction asila ki Mr. Standing Counsel 42 re se प्रवचन
yes
प्रवचन कौन दवा पे जाउछंती बडे से को कोन बाहर मेंबर्स बेसी इंटरेस्टेड अछंती. So then it is the right of the persons is juxtaposed, fundamental right. It's very interesting. Fundamental right is also right to keep quiet. Visual Emmanuel.
Yes.
Jehovah's Witness, they said that we will not sing because we have, now they are saying fundamental right to listen to pravachan. So if the fundamental is listen to pravachan, then pravachaka has a fundamental right to give pravachan.
Both sides have side effects, my lord.
But the great judge actually is not here. It should have been heard by the Hon'Ble. Yeah.
I was there at that time.
Yes. No, he's actually really brilliant at time. I mean, his judgments and all that is really brilliant.
Yes. Although Mr. Kotke was there, I was very much there.
Mr. 43, Mr. Standing Counsel for the State, Mr. H.S. Misra for the opposite party.
42.
Mr. Misra wanted adjournment, but I think he
yes. This is the case, my lord. No, it is on me. Bar extra on me. 42. 42 ta.
42 sala 17 सी adjournment माइतले mention करथिले.
Yes.
हो आपण होले मु नाही he adjourned it, but still then I wanted to any instruction regarding that.
No, my lord.
Okay.
Now, 43 lords, this is a case, my lord, years old case filed in 2003 lords.
Yes.
The petition on behalf of the Department of Vigilance lords, lords, essay an order of acquittal in which both the accused, one accused is accused number one is the supervisor of Kendali Godam lords.
Yes.
And two is he was the transport agent lords.
Yes.
In one line prosecution case, one line.
Operation note कर देले. Standing Counsel and H.S. Misra. Yes, sir. Next, please.
Lords, let me repeat this. There are two accused persons.
Yes.
One accused number one was a supervisor of Kendali Godam situated in Bamara.
Yes.
And
Bamara. Yes.
Accused number two is a transport agent lords.
Yes.
One line prosecution case is the accused number one, the supervisor of that Kendali Godam, while in charge of Kendali Godam at Bamara in the year 1986.
Yes.
With in connivance with the Kendali agent or accused number two, dispatched better quality Kendali.
Yes.
Contrary to the permit, that is Exhibit 2. This is important. The permit contains a particular quality of Kendali, but the accused number one, in connivance with the agent's rods, the transport agency of accused number two rods,
yes,
dispatches better quality Kendu, contrary to the permit. That too, by manipulating the official records and causing pecuniary loss of 12,000 rupees to the Forest Corporation.
Yes.
This is a prosecution case.
Yes, please.
And lords, the issue which was formulated by the London Trial Court is at para 5 of the impugned judgment.
Yes, please.
And lords, I think lords, I'm clear so far the status of these two accused persons.
Yes.
One is the supervisor Kendali Godam,
and one of them has died. One of them has died, and one has, after suffering chronic kidney disease, undergone went to kidney failure and has got a transplant. That was the intimation from Mr.
In fact, that's why I said in one line the prosecution case.
Deposition achi. Because I find somebody has filed in Odia deposition.
So I've got the deposition copy of handwritten.
Handwritten. Here also the same thing. Could you find anything?
Why I say so? Lordship, I recall my one submission. The ground we have taken that this exhibit 2 is the permit, exhibit 5 is the challenge. Lords, the challenge in which the accused number 1 made some correction or entries, lords. And both the exhibit 2 and 5 have been signed and admitted by the accused number 1. In that view, that is the only grounds we have taken in this particular one. Lordship, record this one that London Trial Court should have convicted them because the accused number 1 has admitted because of he has signed in exhibit.
As you were saying that you have to then allege that that signature is beyond his official competence.
That is one line submission. Lordship may record it, and so far this finding is concerned. That is that
judgment copy ta kai miluni कोठी अछि कहले मोर स्कैन कॉपी रे मैं पाउनी पर्यंत
Yes. And here is the case notes.
Judgment copy टा किसी पेज मार्क है चाहिए मुझे पाऊनी अपन को ब्रीफ देखे ले तारीख
page paragraph 8 the Roman 2 page number 32
ଅଛି ପ୍ରେୟାର ପରେ କାହିଁ ତ ନାହିଁ ପ୍ରେୟାର ପରେ वकालतनामा ଆସିଯାଇଛି ଜଜମେଣ୍ଟ ଫାଇଲ ହେଇନି ଜଜମେଣ୍ଟ ହାତ ଲେଖା କେମିତି ହେବ
may I pass on this one?
ଜଜମେଣ୍ଟ ଅଛି ଆପଣଙ୍କ ପାଖରେ
ହଁ
then kindly please hand over. I will return it after
yes,
the order is dictated.
Yes.
The learned counsel, the standing counsel is strenuously referring to the grounds taken in the petition, argued that first and second para, first para pura likhiye subject. The CRLP petition has been filed under so and so and so, challenging so and so for detail likhiye. The learned heard the learned counsel for the petitioner state and the learned counsel for the appearing for the opposite party.
Particularly that accused number 1 admitted and signed in exhibit 2 and 5. In that with the matter, learned trial could have passed on order of conviction. That is one ground we have taken.
Court re file करना है अपन पाइले
non least one. That is the major
scan करना है ताले अच्छा ठीक ଅଛି अपन बाहर ଅଛି ତ देखिए टीआर केस नंबर 271991 से पेज में खाली उल्टे ही देखंदो हैंड रिटन जजमेंट केमती हो
That is the major reason maybe the 2003 and 5 cases that be in the list could not be listed notes.
They were handwritten judgments.
Handwritten and depositions copies.
Yeah, this is judgment.
Oh, yes. We got the certified copies forward.
Certified तो ही चाहिए हाँ certified copy side रे अच्छी चिन्ह तो पढ़ी होनी. It's very difficult.
Only Lakshmi can record that.
आपनकर हम रखिए पड़ो.
This is being tied down.
So this is by Justice C.R. Das, who's now the J1 in Kolkata.
Lakshmi can see the lead petition.
Yes.
The first paragraph contains the one line prosecution case that accused
submitted by the learned counsel for the petitioner that
accused number 1 was the supervisor of the accused number 1
has signed and admitted his signature in exhibits 2 and 5.
For which the acquittal order is wrong.
The acquittal order is wrong. Acquittal order, the order acquitting the so and so accused is wrong.
Prosecution case in the first paragraph of the lead petition.
Acquitting the accused number 1 is wrong. Therefore, the acquittal of the accused number 2 who abetted the crime as far as accused number 1 is concerned is also bad in law. Para. The learned counsel appearing for the opposite, I think accused number 1 has passed away. That was a mistake. So Mishra ତାଙ୍କର ଅଛନ୍ତି ମିଷ୍ଟର କ୍ଲାର୍କ ସେପଟେ ଟିକେ ଆସନ୍ତୁ ଏପଟୁ ମିଷ୍ଟର ଷ୍ଟାଣ୍ଡିଂ ଅଛନ୍ତି ପଳେଇ ଆସନ୍ତୁ ଏପଟୁ ମିଷ୍ଟର ଦାସ just ask him who has passed away. ନା କଣ it is submitted by the learned counsel for the it is submission gala standing counsel ko tapar likhiyo it is submitted by the learned counsel for the appearing for the opposite parties that
died on 29th October 2023 opposite party number 2 Bharat Kumar
the OP number 2 Bharat Kumar Mishra has unfortunately passed away on
29th October 2023.
29/10/2023. In both the submissions, it is agreed at the bar that the petition abets as far as OP number 2 is concerned. Para. Therefore, it is also agreed that as far as the present petition is concerned, it has to be only considered qua petition OP number 1. Para. In response to the submissions of the Learned Standing Council, the council appearing for the opposite party number 1 submits that merely admitting the signature would not be sufficient to prove the guilt of the opposite party number 1, inasmuch as it is not disputed by the prosecution that he has put his signature during normal, regular, official transactions for which he was assigned by the authority. Para. Then I will analyze the evidence.
One line, no cogent evidence has been adduced.
Yes.
To substantiate
then I will analyze the evidence.
To substantiate the
but for that I have to take your help because I have a handwritten judgment.
Correct.
So ଏଟାକୁ ତା ଦେହରେ ଫେରେଇଦେବେ ପରେ ଆପଣଙ୍କ ଟାଇପ ଅଛି ଠିକ ଅଛି ସାର୍ ଅଛି ଏବେ ଡାକିବେ ପାରା ପୁରା ତା ଜଜମେଣ୍ଟ ଡିକ୍ଟେସନ ତାପରେ ଲେଖିଲେ ଡିକ୍ଟେସନ ପରେ ଲେଖିବେ since no perversity could be found in the judgment by applying that test in Ghurelal, the court is not inclined to grant any leave to the petitioner. So we will consider the opinion of this court. The case is not fit where leave can be guaranteed for filing appeal against acquittal. The petition stands disposed of. Yes.
Item 44.
Petitioner none, opposite party blank. Ghurelal ଆପଣ ବୋଧେ କରିଛନ୍ତି ଗୋଟେ କରିଥିଲେ ଆଉ ଗୋଟେ ଥିଲା ଲେଟର ଜଜମେଣ୍ଟ ବ୍ୟାଚ୍ ଟା ଆପଣ କରିକି ଦେଇଥିଲେ ଚାରିଟା ଠିକ ଅଛି ପିକ୍ଚର ପଡିବ opposite party blank. This is item 44. None appears for the petitioner to grant further opportunity. List on 19/2/2024 और से जो पछुआ के डेट फेरौचंती और जते पछु फेरे फेर काली आउथरे डेट मिलिबनी आपनको और थरे जोड़े जाउ ना आकु जानतु बाती जोड़ा नन अपियरेंस होची
45.
केते डेट केते गले एटा 19 देखला अच्छा
45 this is a leave to appeal, my lord.
Yes,
in respect of a
PK Mishra opposite party blank. Yes, next कौन कहते ଆପଣ
it 138 enact acquittal order has been passed against that, my lord.
Highly technical offense ଆପଣ କୋଉଟା satisfy ଯଦି ହେଇ ନଥିବ କେମିତି how to
ସେଇ ଗୋଟା
Mr. Mishra the challenge to grant leave is that I have to analyze the evidence and give a reason.
Yes, of course.
But why this court to overturn the order of acquittal is finding what evidence is there.
Yes.
I will be reappraising the evidence.
Yes.
So for that I will require your help. ଆପଣ ଯଦି କିଛି ପାଉଛନ୍ତି ତାହେଲେ
କଣ ହେଇଛି ଏଥିରେ what has happened, my lord?
Yes.
In fact, this was filed in the year 2007, my lord.
Right.
Thereafter, my lord, during this period,
yes,
the person, the the manager who had entrusted the matter to me, he has already
retired or maybe transferred something.
Company is still in existence. I will take instruction on that.
Carry as per my understanding of information, it is not there.
Yes, I also suspect because I had also given
second avatar, but this company merge करके कौन कर से आउट कंपनी थिला से बंद हो गलानी एटा जो रूम दे थिला
जो जोटा थिला
no I received my AIR volumes there.
Yes,
so
it was a big transport company. Somehow
send it to our
management. Probably
whatever reasons. But then the liabilities and rights have to be transferred to the new entity.
Yes.
All those take again as I mean, if it is a partnership firm or a proprietary,
it has been probably merged with the Kerala Transport Company.
Okay.
So I will have to take instruction whether
come for the petitioner opposite party blank. The Learned Counsel for the petitioner submits that he has to obtain up-to-date instruction regarding existence of the company as on date, as despite his efforts, he has not been able to get any instructions. He seeks accommodation. February, as paid for list on 29.
46.
So Sangram Das standing counsel for the petitioner.
So after petitioners.
Opposite party blank. The line counsel for the petitioner. Seeks accommodation to advance further arguments as paid for list on 18. Again, last of March. 46. You are starting with 46. Yes, next.
47.
Very deleta.
47.
Mr. Naik. So kindly just that original record of the government. I think the item to be mentioned at 2 p.m. I am returning that Mr. Pratap used to take that original record. But you have to return it on the next date.
Okay.
Yes. I didn't. But anyway, I have to give them opportunity. Anyway, yes.
47 I am for the opposite party.
Petitioner none, Ms. Devi, A.K. Devi, Devi for the opposite party. None appears for the petitioner when the matter is called. Upon it out a slip receive kori to rakhi diyo. What a slip to simplify the procedure. Fair after type है कि 10 को देंगे 80 record आसीबे आपण रिसीव करिवे. पर स्लिप रे रिसीव करी आपण रखि देबे तापर सेटा स्लिप से फेरे देबे से चिर देबे. से रेकॉर्ड रे बहिटा थिला रूल्स ऑफ बिजनेस ता लिख ले to grant further opportunity to the petitioner Mr. Yes, Mr. Barik, date item 47 4-3 कोडियो 23. Yes, next please. I'm sorry, 24 4-3 कोडियो 24. 48
man. I am for the petitioner.
Okay, Smanti for the petitioner.
Here is
Mr. Opposite party, Mr. 48 you are appearing, any one of you?
Mr. Mahapatra is appearing, but
Mrs. Mahapatra, OP1, copy is blank.
Copy is not there.
Vicky Patnaik kona se bonus chali rahi na?
Yes, ma'am. So I think so electricity.
Doctor asthile. Na electricity no. Jeta challenge heichi discharge ta.
Discharge ta kon thibo? Apan instruction nebe na kon karbe?
Informant asthila stay achi. Stay ta thibo. Informant asthila 302 ta add hei nathila boli. 307
Informant asthila challenge kala discharge of the opposite party.
Yes.
Stay kain kala?
Stay 307 ta hitla boli setole hei jaichi 11
विचित्र केस.
Inadequacy of sentence. Inadequacy of sentence.
माने accuse करिया कथा informant
तो लीक दरकार नहीं वाली केस रे.
नहीं ऐसा judgment है नहीं. हाँ? Judgment है नहीं.
Judgment
ना ना discharge को charge को challenge कर.
Oh sorry sir, sir.
ମାନେ ଆପଣ କହିବେ ଯେ ଷ୍ଟେ ହେଲା ଏଥିପାଇଁ ଯେହେତୁ 307 ରେ ଟ୍ରାଏଲ ଫେସ୍ କରିଥାନ୍ତେ ଆପଣ ଚାହିଁଲେ 302 ପାଇଁ ହଁ ସେ ବି ଗୋଟେ ଲଜିକ
ଯେ ଅବିକି କେସ୍ ଅଛି ନା ନାହିଁ
ଷ୍ଟେ ହେଇଯାଇଥିଲା କହୁଛନ୍ତି ଏସିଆନ୍ ରିସର୍ଫେସିଂ ଭିତର ହେଇଗଲା ପରେ ସେ ସରି ଯାଇଥିବ
ଅଟୋମେଟିକ ଭ୍ୟାକେଟ ହେଇଯାଇଥିବ
ହେଇନଥିବ
ସେ ଯାହା ବି ଥିଲା ସେକେଣ୍ଡ ଏବେ ଜଜମେଣ୍ଟ ପ୍ରୋନାଉନ୍ସ ହେଇଗଲା କାଲି ରିଜର୍ଭ ହେଲା ଏସିଆନ୍ ରିସର୍ଫେସିଂ ୱାଜ ରିଜର୍ଭ ୟେଷ୍ଟରଡେ
ରେଫର ହେଇଥିଲା
ରେଫର ହେଇଥିଲା.
That will be reconstructed. As it seems.
Because the Lawyer Counsel for the petitioner seeks accommodation to obtain up-to-date instructions in the matter regarding the status of the pending trial. How much time upon keep ani pare? Second Asian resurfacing order hela pare pray अब किसी case रहिलानी. Second order जो हला. First जहाँ भी doubt थिला second Asian clarify कर देले
instruction नहीं अच्छी भी.
ये third रे जहाँ हबो. कित February as paid for list. List 28 2 2023 2024. Yes. Next, please. Mr. Moon.
I am for the petition member.
Yes, please.
I pray Lordship the 1 week after maybe.
Okay, day for the petitioner. Mr. Naik, you are there for?
I have objection, my lord.
You are for which?
For the opposite party.
138.
138.
130.
It's checked in the
Advance arguments. The learned counsel for the opposite party has some states his objection to the prayer of accommodation. You are saying that the money has not been deposited. Conditional order enough like
no.
Can conditional order hela na? Usually to stay here conditional order hai ki
nahi ki kshetra rahi.
Hey. No 25% deposit koriya pra.
No, no, no. Hey nahi.
25% कहउछन परा?
No, no. Or can have last to order sheet mele. खाली स्टेट रिलेशन फाइन बेल ହେଇଛି 4,99,000 almost 5 lakhs my lord case of the year 2011
तो लोकल को जाइଥିଲା 22/11 रे
ई लोक टर्न कोनिया
लोक टर्न न कले केस एंड हमार असुविधा
मैं 1 week after maybe instruction
छुट्टी पर आसियो आगो
हां ठीक है
the learned in response to the learned counsel for the petitioner submits that despite her efforts, the petitioner has remained incommunicado. Now, how to go what change कर लिखी दियो? Despite her efforts, there has been no instructions from the petitioner at present. Para. In view of the prayer of the petitioner, prayer made on behalf of the learned counsel for the petitioner, list on February 1st aru diyo first week
अच्छा last chance mein
last chance कौन हो कि एथरे last chance किछि नहीं आपण 6 दिन बॉन्ड ऑफ 30,000 निकला
चेक टा 4 लाख आवश्यक
स्टम 6/2/2024 आपण भी एथरे मिस्टर नायक यू शुड आल्सो माने go for a persuade your client for mediation.
I am ready.
Mediation code asila pare ए सब जिंस को litigation adversarial litigation is not
offer dele आमे तो
आपण करू नांती आया
हाईली के आगे से
8 लाख टका हेइतला
से आपण इज नॉन कंडीशनल ऑर्डर हुए ता परिणत होची एटा यदि कोइ थाते सब्जेक्ट टू डिपॉजिट ऑफ 1 लाख रुपीस which shall be without prejudice to the rights and contentions ताले से सुनी थांदे आपण कथा ଆପଣ ସେ ଅର୍ଡର କହିଲେନି କାହିଁକି ସେ ତ ଆକ୍ସେପ୍ଟ କରିଥାନ୍ତେ ଲକ୍ଷ ଟଙ୍କା ଉଇଦାଉଟ୍ ପ୍ରିଜୁଡିସ୍ ତାଙ୍କର 4 ଲକ୍ଷ ପାଇବେ କି 10 ଲକ୍ଷ ପାଇବେ ଲକ୍ଷ ଟଙ୍କା ଆକ୍ସେପ୍ଟ କରିଥାନ୍ତେ
ଏଠି କମ୍ପେନସେସନ
many cases the court is directly and they are withdrawing the amount ସେ ମନି ସୁଟ୍ ହେଇନଥିଲା ତ ମନି ସୁଟ୍ ରେ କେତେ ଗୁଡେ ହେଇଯାଉଛି ସେମାନେ ଆମାଉଣ୍ଟ ୱିଡ୍ର କରୁଛନ୍ତି ତାପରେ ଆଉ କେସ୍ ରହୁନି
ଏ କେସ୍
ରେ one matter this has happened
hopefully I am also suggesting compensation ହେଇଛି 8 ଲକ୍ଷ ଟଙ୍କା ସେଥିରୁ ଲକ୍ଷ ଟଙ୍କା କମ କରି ମଧ୍ୟ ଦେଇଦେଲେ ମଧ୍ୟ क्लोज ହେଇଯିବ
ସେ 7 ଲକ୍ଷ ଯଦି ଆପଣ 6 ଲକ୍ଷ ରାଜି ହୁଅନ୍ତୁ
କରନ୍ତୁ ସେତିକି
କରନ୍ତୁ but you have to make that effort and the major challenge that why 12 ମସିହା ପରେ କାଇଁ ଆସୁନାହାନ୍ତି because there is no order no conditional order they will not listen to the lawyer
କିଛି ଦେଲେ ମାନେ ଅଫର ଟେ ଦେଲେ ସେଟା ଗୋଟେ ଡିସ୍କସନ କୁ ଯାଆନ୍ତା
and for 6 lakhs for 5 lakh pounds of check it is not 5 lakhs
4 lakhs
ना 4,99,000
499 आज्ञा bon टंका दा जणा पडोनी कोन so 5 lakhs by 6 lakhs is a very reasonable offer sorry
नेक्स्ट डेट धरि के आसन सार दवा
जणा पडोनी टंका आज्ञा बहुत केस है गलानी से
मतलब आइटम 50 preferred after vacation मतलब
पहले बिल्कुल प्रोडक्ट सर मिस्टर तबे इनपुट्स बड़ा प्रोडक्ट
कहीं चैलेंज कोन
नो स्टेट इज मिस्टर Mahanti or Patnaik
S Patnaik
Mr. S Patnaik for the petitioner Mr. Standing counsel for OP1 OP2 blank P2 none OP2 none the learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions and advance arguments. The learned standing counsel submits that considering the nature of prayer, that is challenge to the order of taking cognizance. Nothing would survive after a lapse of 11 years. Para. However, to grant further opportunity to the petitioner, केबे चाहूँचंती? February list. मार्च को फर्स्ट वीक में केबे देखलेनी परे आपण? 5/3/2024.
51
मेंशन करथिले 51 टा कि ता नाडा कोन खगेश्वर बेहरा on behalf of Aniruddha Das for the petitioner, opposite party blank. The lawyer counsel for the petitioner seeks accommodation to obtain up-to-date instructions and advance arguments. As paid for list on 6 Aniruddha Das.
Item 52.
Miss M.S.S. Panigrai on behalf of Samir Kumar Mishra for the petitioner. Mr. Opposite Party Blank, the learned counsel for the petitioner submits that he may be accommodated to obtain up-to-date instructions from the petitioner as paid for list on 27/2/2024.
53.
Commissioner now.
On behalf of Tushar Kumar Mishra, I pick
Madam, I'm sorry.
P. Yostia.
Miss P. Bastia on behalf of T.K. Mishra for the petitioner. Opposite party none. The learned counsel for the petitioner seeks accommodation to advance arguments.
It is also infructuous, framing of charge.
The learned standing counsel appearing for the state of OP number 1. Opposite party blank no. OP number 1 is standing counsel. OP 2 none. Honestly, sorry. Submits that the matter would have been rendered, nothing would survive at present for adjudication as a challenge to
stay.
State आपनका second वैसे डिस्टर्बेंस से सफा है गला सब state.
Infructuous.
That is the challenge was to the order of taking cognizance. Framing of charge. Order framing charges against the petitioner. Nothing would survive at present for adjudication before this court. After the judgments passed by the Honorable Supreme Court in the Asian resurfacing. To grant further opportunity to the petitioner, Mr. 28/2/2024.
Blessed.
Yes.
54.
Mr. Sabit.
May I please?
Yes. Yes.
The petitioner challenges the order passed by learned additional sessions judge in the sessions trial under Annexure 9, my lord.
Acquittal.
No.
Against declaring two of the accused persons as juvenile. Yes, come before this.
Discuss, I am for the opinion number 6.
It's not
कौन हला जुवेनाइल डिक्लेयर कला परे
Declare for the case was split up and
Sent to the
juvenile court. Juvenile court.
ସେଇଟା ଚ୍ୟାଲେଞ୍ଜ କରି ଆସିଛନ୍ତି ଯେ
स्थिति वर्तमान स्टेटस कौन अछि
ସେଇଟା
जुवेनाइल कोर्ट रे
I will take instruction.
एइटारे इट्स वेरी डिफिकल्ट स्कोप फॉर इंटरफेरेंस converse is true that at any time he can take the plea of juvenility.
But
But how the informant will have a say as far as plea of juvenility is concerned?
my lord, the documents supplied by the opposite part number 6 and 8, there are lots of discrepancy and the evidence used by the
discrepancy pointed করছেন but here the difficulty is that how that can be used by the you are the informant. ତାହେଲେ ଆପଣ ତ ଆପିଲ ଚ୍ୟାଲେଞ୍ଜ କରିବେ ତାଙ୍କର କନଭିକ୍ସନ ଆକ୍ୟୁଟାଲ ହେଇଗଲା ଆପଣ ଆପିଲ ଚ୍ୟାଲେଞ୍ଜ କରିପାରିବେ
on the ground.
Madam, kindly consider what I am discussing. Kindly consider. ତାଙ୍କର ବର୍ତ୍ତମାନ ଜୁଭେନାଇଲ କୋର୍ଟରେ ଜୁଭେନାଇଲ ଜଷ୍ଟିସ କୋର୍ଟ କୋଉଠି ଟ୍ରାଏଲ ହେଲା ସେପଟେ ଟ୍ରାଏଲ ହେଲା ସେ ଟ୍ରାଏଲ ରେ ତାଙ୍କର କଣ ଆକ୍ୟୁଟାଲ ହେଇଯିବ
ଆକ୍ୟୁଟାଲ ନାହିଁ
ହବନି
no.
ସୋ ଆକ୍ୟୁଟାଲ ନହେଲେ ଆପଣ ଯଦି ଆକ୍ୟୁଟାଲ ହେଲା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିବେ যদি acquittal,
My contention is that they are not juvenile.
how
On the basis of the-
who will decide that at first stage? That's the question, madam.
Only one point, my lord.
No, one point ଆପଣ ଆଗ law ଟା ଦେଖାନ୍ତୁ। ଆପଣ problem ହେଲା କଣ କି ଆପଣ straight away evidence କୁ ପଳେଇଲେ। There is lot of discrepancy. Who will decide that? Can a judge, can a high court prejudge that before the matter is considered by the court of jurisdiction? Acha, whenever order granting juvenility is granted, accepted by the court,
Yes.
that is to be challenged by the prosecution. Have they challenged it?
No.
Then suppose now I determine that he is not a juvenile. Let us assume it goes in your favor. What will happen?
I am
He will face trial.
Yes.
Accused will face trial like a normal person, normal citizen who has been accused of. Then what would happen if he is ultimately found to be a juvenile?
Ultimately found juvenile on the basis of wrong.
ଆପଣ case law କଣ examine କରିଛନ୍ତି କି? ଆପଣ ଏଟାକୁ adversarial କରିଦେଲେ। problem ହଉଛି କଣ କି ଆପଣ ଗୋଟେ normal civil suit କି complaint case ଭଳିଆ argue କରୁଛନ୍ତି। ଏଟା ସେମିତି କରିହବନି।
I have to examine.
This is not an adversarial proceeding. ଏଥିରେ neutral prosecution। ଆପଣ ହଉଛନ୍ତି witness। ଆପଣ ବରଂ examine କରିବା କଥା ଯେ provision of law କଣ ଅଛି that if the informant is aggrieved by the plea of juvenility of the judge, because still he is facing trial. And the objective and the objective is that he cannot face trial like a normal normal accused post 18 years. So that how can I judge now much before it is considered by the learned court in, because suppose he is taken to be a juvenile before that court also, now this amendment has come in case of a heinous crime. So he can be tried as a normal offender.
There are offenses under section 341, 323, 451, 342.
Seriousness of offense is not an issue here. Because you see, I can't comment that easy to submission that in certain offenses, juvenility has to be considered by the High Court in appeal.
No, there is.
That you have to show.
Yes, ma'am.
That you have to show in law that before the court considers it. I can simply, you see, your prayer is to consider to set aside the order granting the benefit of the juvenile.
Yes.
Juvenile Justice Act. Beyond that, you don't pay anything.
No.
ଆପଣ ସେଇଟା examine କରନ୍ତୁ।
Yes.
ଆପଣ କଣ plea ନେଇଛନ୍ତି? Anyway, ଆପଣ କଣ କହୁଥିଲେ?
My contention is that the
order ଦେଖାନ୍ତୁ। contention ରେ କିଛି କରିହବନି। If you are in a revision, ଆପଣ straight away କଣ writ petition ହେଇଛି ଆରମ୍ଭରୁ argument ହବ। କୋଉ part ରେ ଆପଣ wrong ବୋଲି କହୁଛନ୍ତି the court went wrong, which part? This is only adding to the pendency of the court. Nothing substantive adjudication କିଛି ନାହିଁ।
Page 3 of the judgment, my lord.
Judgment ଟା କେତେ annex sir?
Annex 9.
Yes.
Last para. In the instant case, the accused persons had relied on the
ଆରମ୍ଭରୁ ପଢନ୍ତୁ। Page 30 ବୋଧେ ସେଟା dated 20/8/2013।
Then the petition filed under section 7A, read with section 18 of the Juvenile Justice, Care and Protection of Children Act on behalf of the accused Purnachandra Vishal and Paramananda Vishal, claiming to be juveniles in conflict with law by the time of incident. Along with the petition, accused Purnachandra Vishal has filed a school leaving certificate issued from Bagdevi Sanskrit Vidyalaya, Uttildia, wherein his date of birth has been reflected as 10/6/1983. Accused Paramanand Vishal has filed a transfer certificate issued from Ma Basanti Vidyalaya, Sindhya, wherein his date of birth has been reflected as 10/5/1986. The learned defense counsel submitted that as per the complaint petition, the incident took place on 13/3/97, and as such by the time of incident, accused Purnachandra Vishal and Paramananda Vishal were less than 16 years of age, and accordingly they be declared as juveniles. In the matter of Jyoti Prakash versus State.
Madam, you have no case.
My lord.
भोला भगत से साइड कले तापर मुटे खूब जल्दी पढ़ी देली. You have no case.
My submission may be.
Submit करंतु नहीं. Submission has a difficulty. I have no such power that I will ignore the judgment and evidence and directly take note of your submission. Because without bereft of me considering the judgment and the evidence, I cannot. First will come the judgment where you are agreed to अपन पढ़ंतु मुटे जल्दी पढ़ दिल पढ़ंतु ठीक अछि. ठीक carry on. तापर अपन बुझी परे why I am saying so. पढ़ंतु.
Has been held that person brought before Sessions Court for trial claiming to be a juvenile. Sessions Court is competent to determine the incident where such a person is a juvenile under Section 32 of the said Act.
Yes.
In the matter of Bhola Bhagat versus State of Bihar reported in 1998, Volume 14 OCR Supreme Court, page 30, the Apex Court has given direction to all the subordinate courts that when a plea is raised on behalf of the accused that he was a child within the meaning of definition of the expression under Juvenile Justice Act, it becomes obligatory for the court, in case it entertains any doubt about the age as claimed by the accused, to hold an inquiry itself for determination of the question of age of the accused or an inquiry to be held and seek a report regarding the same, if necessary, by asking the parties to lead evidence in that regard. In the instant case, in view of the settled principle of law, the petition was accepted for inquiry and both the accused persons were allowed to lead evidence in support of their claim. Accused Purnachandra Vishal was examined as PW1. The school admission register of Nima UP school was called for. The headmaster of Nima primary school, namely Sudarshan Murmu, produced the school admission register on the said school, and through him, the date of birth of accused Parmanand Vishal reflected in the school admission register as 10/5/1986 was marked as Exhibit 1. As per the said relevant entry, accused Parmanand Vishal was admitted in Class 1 on 11/7/1991. On the prayer of the accused persons, the headmaster of Manduru Kula Primary School was summoned to produce the school admission register from the year 1988 to prove the date of birth of Parmanand Vishal. The headmaster of the said school, Kartik Chandra Padhia, appeared in court and was examined as PW3, and in his evidence he deposed that school admission register of the school was lost from the year 1988. Again, the headmistress of Vagdevi Sanskrit Vidyalaya, Putultia, was summoned to produce the school admission register of the said school. She produced the school admission register, and as per the said admission register, Purnachandra Vishal was admitted in Class 5 on 7/7/94 and his date of birth was 10/6/1983. He was admitted on the basis of the transfer certificate issued from Nima UP school. The said transfer certificate was also produced in the court, which was marked as Exhibit 3, and as per the said transfer certificate, date of birth of the accused Purnachandra Vishal was 10/6/1983. Rule 12(3) of the Juvenile Justice Care and Protection of Children Rules 2007 defines, in every case concerning a child or juvenile in conflict with law, the age determination inquiry shall be conducted by the court or the board, as the case may be, committed by seeking evidence by obtaining the matriculation or equivalent certificates, if available, and in the absence thereof, the date of birth certificate from the school other than a play school first attended, and the absence thereof.
Juvenile Justice Act Care and Protection 12(3)(a)(2) Roman 2 अच्छी. Actually, in a conservative estimate, his date of birth should be 85, not even 83.
Two persons. One is saying that my date of birth is 83, and the other is saying that.
से जो विश्वाल रा परमानंद विश्वाल टा दिथर आनछन्ते आपण परमानंद विश्वाल टा प्रथमे देखंतु से क्लास 1 ने केबे पढिला
पूर्णचंद्र विश्वाल 10/6/83.
परमानंद विश्वाल ना पूर्ण पूर्ण जने परमानंद जने.
He is saying that
परमानंद so now yes, so आपनकर 10 ये अच्छी 10(a)(3) अच्छी 2 अच्छी
2
अच्छी. हाँ ठीक अच्छी. तबे तोड़ आसंतु
The birth certificate given by a corporation or
in case gala, tapare,
only in absence of either 1, 2, 3 of clause
case
6.
in case exact assessment of this cannot be done, court board case may be committee recorded by them and considered necessary give benefit to the child. But here primary evidence is there. Chhad diyantu. Then Ganga Ganadhar city, Sapara.
Ganga Gadhar City versus State of Orissa reported in 2011 1 ILR Cuttack. Page 9 to 6 is Lordship. I Mahanti held that when the school school admission register showing the date of birth of the petitioner, there is no justification for the magistrate to seek for any medical opinion.
That is what the rule is.
Yes.
This is a special statute. Once 12A2 is available, then you cannot go to the medical evidence. 12B re. 12(3)B re medical evidence. So the magistrate go rule obviously. So Justice Mahanti is right. Anyway, next. In the instant case?
In the instant case, the accused persons had relied on the school admission register to prove their date of birth. The school admission registers of the accused persons from the school first attended by them were called for and the date of birth mentioned there in were proved through the headmaster of the concerned schools. As per the school admission register, the Nima UP school, where the accused Parmanand Vishwal has taken admission in class 1, his date of birth has been reflected as 10/5/1986. As per the school living certificate issued from Nima UP school, where Purnachandra Vishwal had taken first admission into school, his date of birth has been reflected as 10/6/1983. In view of the principles of law discussed above, I accept the date of birth of accused Purnachandra Vishwal as 10/6/1983 and accused Parmanand Vishwal as 10/6/1986 as appeared in the school admission register. And since the my contention is that the
first contention is that cool part judgment you are agreed.
Yes,
state or point
this part my lord.
The conclusion conclusion agree challenge kay korthante samasya question je conclusion I am agreed. Court where the court ordered that to show that it's a perversity. Seta dekhantu court bhulela.
Court has not considered the evidence of the accused OP number 6.
12(3) ପଢନ୍ତୁ 12(3) OP6 କୋଉଠି ଦେଇପାରିବ ଯେ ଆକ୍ଟ ଯେହେତୁ କୋର୍ଟ ହେଇଛି 12(3) ରେ OP6 କୋଉଠି ଦେବ OP6 କିଏ
OP6 claiming himself as juvenile. Opposite part number 6.
ଏଥିରେ
Yes.
ଆପଣ ତାର ଯୋଉ କହୁଛନ୍ତି ଜୁଭେନାଇଲ ଷ୍ଟେଟମେଣ୍ଟ କୋଉଠି ଆପଣ 12(3) ରେ ରେକର୍ଡ କରିବେ
Shall be conducted by the court.
Madam, judges are not given that much of discretion in a. Then it is not judging. It is becomes arbitrary. को magistrate चाहिले से माने record करिवे तांकर को magistrate चाहिले public opinion नेबे को magistrate चाहिले बापा मां को डाकी पचारिवे. That is how the special statute provides a mode of determining the age. What is a admissible evidence in case of a claim of juvenility? Court सेडा तांकर नबो को नांती आपण justify that.
Another.
Let us assume a juvenile commits a crime.
Yes.
He says that I am 25 years of age. Court will consider 12(3) or take a statement because he says I am 25. He is inspired. Let us say he is inspired by some movie and something. He is saying that, claiming that I am 25. But on the face of it, he is a juvenile. Record says it is juvenile. Can a juvenile opt to be tried as a normal adult by giving a statement?
That is not.
Cannot be.
Yes.
Cannot be.
Another point.
Then becomes then the whole process becomes too uncertain, arbitrary.
One minute, I may be allowed.
No, you are being allowed. But the problem is that you are not opening up your proposition. Once the court responds quickly, then you are struggling to respond to that. I could have taken after half an hour I would have responded, but that is wastage of time.
I will examine that point.
तो आपनकर कोर्ट रे आपण किछटा एग्री नहीं परिबेनी एथरे.
Only one point, my lord.
Your submission that the statement of the juvenile was not considered
Yes.
is on the face of it is palpably wrong. If the court would have done that by arriving at a conclusion that he is a juvenile, then that order is vulnerable. The court has not done that. Court should not do that. Even medical evidence, as held by in the decision of Gangadhar Sethi,
Yes.
medical evidence is because you see, ଆପଣ ଟିକେ 283B ଟା ଦେଖନ୍ତୁ.
Yes.
କଣ ପଢନ୍ତୁ?
Only in absence of either one, two, or
three or clause A.
Above
Medical opinion.
medical opinion will be sought from
ତାପରେ ଶୁଣନ୍ତୁ, ତାପରେ again interesting. In case exact assessment of the age cannot be done, the court or the JJB, as the case may be, the committee for the reason to be recorded by them. ଆପଣଙ୍କର sir, madam, ଏଥିରେ କେବଳ ରହିଲା 1, 2, 3,
Yes.
then medical opinion, then ଯଦି ନ ମିଳିଲେ ତାହେଲେ court, then board for the reasons to be recorded. ଆଉ ତାପରେ 7th option ନାହିଁ. ଆପଣ 7 କଣ ଆପଣ 8th option କୁ ପଳେଇଲେଣି. ଆପଣଙ୍କର contention should be based on law. ଆପଣ breadth of law ଆପଣ କେମିତି କହିବେ ଯେ ଇଏ ଅମକ ଲୋକ ଷ୍ଟେଟ ଦେଲା, ଗୋଟେ ଜନମତ ସର୍ବେକ୍ଷଣ କରାଗଲା, 100 ଜଣ ଲୋକ କହିଲେ ତାକୁ ଦେଖିଛନ୍ତି ଡେଟ୍ ଅଫ୍ ସେ ଜନ୍ମ ହବାର 1980 ମସିହାରେ.
Another point, my lord, the case
ଆପଣ juvenile the constitution, let us finish that.
only
ଆପଣଙ୍କର yes, ତାପରେ ଆପଣ yes, what you want to say, ଆପଣ କଣ କହୁଛନ୍ତି?
the case was registered against opposite party number 8, Sri Bannamali Biswal. But court held that, Learned Court held that the Paramananda Biswal.
How that is material?
10 persons.
ସେଇଟା ଆଜ୍ଞା ସେଇଟା ତ ଆପଣ ତାଙ୍କ ଫେଭରରେ କହୁଛନ୍ତି.
It's not
ଆଜ୍ଞା ଆପଣ ପରମାନନ୍ଦ ଫେଭରରେ ସେଇଟା ଆର୍ଗୁମେଣ୍ଟ କରିବେ ନା ସିଏ କରିବେ ସେଇଟା? Regarding identity of the accused, he will argue that Banmali will come to court or Paramananda will come to court. ଆପଣ ସେଇଟା informant କଣ argue କରୁଛନ୍ତି?
because I am
ଆପଣ ତାଙ୍କ ଫେଭରରେ argue କରୁଛନ୍ତି ସେଇଟା. If Banmali is the accused and you seek Paramananda to be implicated as an accused and tried.
no Bannamali should be
ସେଟା ଆଉ ଗୋଟେ ପିଟିସନ ହବ. ସେଟା ଆପଣ ସେଠି ଫାଇଲ କରିବେ, ପ୍ରୋଟେଷ୍ଟ ପିଟିସନ ଫାଇଲ କରିବେ. ସେଠି ଡିସାଇଡ୍ ହବ. ଆପଣ ବନମାଳୀର not being charge seated accused, Banmali having not been charge seated, if I understand whatever understanding I have, this is not a provision. ସେଠି ଆପଣ ସେ charge framing stage ରେ ଆପଣ protest petition file କରିବେ.
and that after the date of birth the document.
ଆପଣ ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି, that is challenging order accepting juvenility of the
opposite party.
Paramananda and
Bannamali.
Prabhakara.
Bannamali. That is Paramananda. Bannamali, he is saying that Bannamali and Paramananda is same person. Opposite party number 6 is saying.
ସେଟା ଛାଡନ୍ତୁ.
That is conflict with my lord.
ସେଟା ଏଠି କରିହବନି କିଛି. ଆପଣ ଯଦି ସେଟା କହିଲେ ମତେ ଆଉ ଥରେ ହବାକୁ ପଡିବ ସେ ଟ୍ରାଏଲ କୋର୍ଟ, ସେଟା ହେଇପାରିବନି ଏଠି. ଆପଣ ଯଦି ବନମାଳୀ ଅଛି ପ୍ରମାଣର ଅଲଗା ଲୋକ ସେଟା ସେଠି ଫାଇଲ କରିଛନ୍ତି କି କିଛି ସେଠି, ସେଟା କିଛି କରିହବନି. ଯୋଉ ଲୋକଟା ଜୁଭେନାଇଲ ତାର ଜୁଭେନାଇଲିଟି ଏଗେନ୍ଷ୍ଟ ଆପଣ ଆସିଲେ, ଯୋଉ ପିଲାଟା ଜୁଭେନାଇଲ ବୋଲି କହୁଛି, ସେଥିରେ ଆପଣ କହୁଛନ୍ତି there is a conflict of identity. So in a criminal case, conflict of identity is the last thing for trial. The trial will not survive. যদি ଥାଏ, that is in his favor.
But that is another person, not Bannamali.
ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି. ଆପଣ ଯୋଉ କହୁଛନ୍ତି another person, ତା ଅର୍ଥ କଣ? Another person is an adult.
Adult.
What is this?
As Bannamali, he is claiming that I am juvenile. But court
ଆପଣ judgment again ଆପଣ forgotten what you have read. ଯେତେ ଜଲ୍ଦି ଭୁଲିଗଲେ କେମିତି ହବ? But just now ପଢିଲେ ନା ଯୋଉଟା କୋଉ ଦିନ ଲୋକ पढ़ो again now फिर move जान कोडिया
I have to examine, my lord. I may ask my lord
it's not the
some time, my lord.
this is not the way to argue matters. ଆପଣ ଥାର୍ଡ ଲାଇନ ଲେଖିଲେ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ବିଶ୍ୱାଳ ପରମାନନ୍ଦ ବିଶ୍ୱାଳ ଜଜମେଣ୍ଟ ପଢିସାରିଲେ ଆପଣ ବନମାଳୀ କଥା କହିଲେଣି
Purnachandra is one person.
ପରମାନନ୍ଦ ଆପଣ ଏଠି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଡିକ୍ଲାରେସନ ଅଫ ଜୁଭେନିଲିଟି ଅଫ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ଆଣ୍ଡ ପରମାନନ୍ଦ
Banamali.
now ବର୍ତ୍ତମାନ କହିଲେଣି ବନମାଳୀ should have been arraigned as a charged as an accused.
I am challenging the juvenility of Purnachandra Vishwal OP number 6 and Banamali Vishwal OP number 8. But
the petition should be outright dismissed. ଆପଣଙ୍କ ଜଜମେଣ୍ଟ ହେଲା ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ପରମାନନ୍ଦ ଆପଣ ବନମାଳୀ ବୋଲି ହାଇକୋର୍ଟରେ ଫାଇଲ କଲେ ନା ସେଟା ସେଠି କରିବେ
no, no.
ଆପଣ ଟିକେ ପଢନ୍ତୁ
Trial be
ଆପଣ ଟିକେ ଯାଆନ୍ତୁ ଟିକେ 30 କୁ ଯାଆନ୍ତୁ 28/2/13 ଜଜମେଣ୍ଟ କୁ ପଢନ୍ତୁ ଏତେ ନନ୍ ପର୍ଟିକୁଲାର ହେଲେ କେମିତି ହବ ମ୍ୟାଡାମ କୁଆଡେ ଉଠଉଛନ୍ତି କେଜାଣି ଆପଣ ଇମ୍ପୁଲ ଅର୍ଡରଟା ପଢନ୍ତୁ
from the beginning, my lord.
ହଁ ଥାର୍ଡ ଲାଇନରେ କଣ ଲେଖା ହେଇଛି ପଢନ୍ତୁ
In the matter of Bhola Bhagat versus State of Bihar.
Shade Nomo had a petition filed under section 7A. Opening line of the judgment you are impugning here.
Yes.
Had on the petition filed under section 7A, read with section 18 of the
juvenile
Care and Protection Act on behalf of the accused Purnachandra Vishwal and Paramananda Vishwal.
Paramananda Vishwal.
Then you are not agreed by the declaration of Paramananda as a juvenile.
No.
Can't tell a challenge କରୁଛନ୍ତି You confine your submission to Purnachandra. The trial court stay ହେଇଛି
Yes.
trial case stay କରାଗଲା
No, judgment was stayed. And issue 9 was stayed by this honorable court. Order dated 3/1/2014.
So बाकी ट्रायल में कौन है टोटल जुवेनाइल दी जण बाकी अन्य मानकर कौन है ताकर स्टे ହେଇନି
No.
trial ta stay ହେଇନି the order declaring them to be juvenile has been stayed then what happened
That I have to take instruction.
this item 50 Miss M.S.P. Patnaik for the petitioner Mr. You are Mr. S.K. Mishra.
S.K. Mishra.
For?
OP number 6.
OP number 6. OP 1 by Mr. 54, who is there? 54, Mr. Standing Counsel or Mr. Mahapatra, Mr. Nayak, 54?
54. 54.
54 by Mr. Standing Counsel for the State. The Learned Counsel for the petitioner submits that he has no opportunity instructions regarding the present status of the trial pending before the Learned Court. And she may be accommodated further. The Learned Counsel for the petitioner was heard at regarding the merits of the contentions as far as challenge to the order dated so and so passed by the Learned Court so and so in case number so and so declaring the persons Mr. Sri Paramananda
Sessions trial भी मतलब बनमाली अछि
ଆପଣ ପୁରା କନଫ୍ୟୁଜ ହେଇଗଲେଣି ଆପଣଙ୍କର you are not concerned with ବନମାଳୀ ଆପଣ ବନମାଳୀ ଏଠି ଚ୍ୟାଲେଞ୍ଜ କରୁନାହାନ୍ତି 28 order is very clear 28 order has been stayed
yes
ବନମାଳୀ ଯଦି ଆରେ ହେଇନାହିଁ ପାର୍ଟିରେ ତାହେଲେ that's a different proceeding
अरे ହେଇଛି
ଯେତେବେଳେ ଟ୍ରାଏଲ ତାର ହବ ତାର ଷ୍ଟେ ହେଇନି ଆପଣ ଯଦି ବନମାଳୀର ଆପଣ କହୁଛନ୍ତି ବନମାଳୀ has been charge sheeted as an accused final prosecution report has been submitted regarding ବନମାଳୀ ଆପଣଙ୍କର ପିଟିସନରେ ନା କିଛି ଅଛି ନା 28 ଅର୍ଡରରେ କିଛି ଅଛି कौन लिखले
पिटिशन अछि
ପିଟିସନ ହେଲେ କେମିତି ହବ?
अरे सेटा आपनकर इश्यू हेनी एथिरे जे बनमाली परमानंद एका लोक कि अलगा लोक दैट्स नॉट एन इश्यू इन कोरिया ऑर्डर
सेटा हे
आपण कहीं सेटा एथिरे कहउछन मु भी किछि बुझी पारने एक्चुअली कौन लिखले डिक्लेयरिंग वन श्री परमानंद विश्वाल इनटू ब्रैकेट ओपी नंबर
এটা 8
एंड पूर्णचंद्र विश्वाल आगे पूर्ण लिखो तापर परमानंद लिखो पूर्णचंद्र विश्वाल
OP number 6
OP6 and Purnapurana Bishop OP8 to be juveniles. MFSA, this court doesn't find any perversity in the order dated 28/2013. After going through the said order, it is seen that in terms of the JJ, Juvenile Justice Care and Protection Act, the court has proceeded in accordance with law as per the mandate of the rule 12 into bracket 3 of the JJ into bracket Care and Protection of Children Rules 2007 by examining the school admission register in terms of the rule 12 into bracket 3 into bracket small English a into bracket Roman 2I. Hela. The learned counsel for the petitioner तापरे आपण पेज 5 देखिले माने इंटरनल पेज 5 रनिंग पेज 33 जोटा आपण ऑर्डर लास्ट कंक्लूजन पार्ट ता देखो therefore the case against dictation ता कोने आपण लिखिबो गांतनी therefore the case against accused Parmanand Vishwal and Purnachandra Vishwal will be split up आपण बनमाली चलेचन से तो
এটা পিটিশন
बनमाली split up भी नहीं गया suppose assuming
यस यस
आ जदी आपण बनमाली को से अच्छा बनमाली भी ट्रायल फेस करूची आपण कहउछन बनमाली वाला जुबे नै
यस
आ ताले से प्ली बनमाली नबो ना कंप्लेंट नबो बनमाली गोटे पिटिशन फाइल करबो जे एक्ट रे से मु भी जुबे नै
No, no. The OP number 6 is saying Bonnamali and Paramananda is the same person.
Trial, madam.
Same person.
That's it, trial, madam. Jodi OP number 6 सेटा कहि परिबोनी सेटा कोर्ट डिसाइड करिवो.
Meaning he is saying that
prosecution सेटा करिवो. Prosecution आपन कर there is a presumption of innocence.
Yes.
आपन जो बनमाली कथा एते थरा कहले in fact there is nothing referring to बनमाली.
In his evidence OP number 6 is saying that he is my brother. Bonnamali and Paramananda is the same person. He is my brother.
Let us accept that.
No, no. He is evidence.
Again, let us accept your statement.
Yes.
Then what next? सेटा मो पचारचे आपन को.
Same person.
अरे he is my brother कहले same person बोले कोन कहउचंती?
He is saying that he is.
So तार कोन relevance अछि? कोन आपन जोटा you have to make a legal submission. तार कोन relevance अछि determination कोन लिखले? Scholar, the learned counsel for the petitioner has not brought anything before this court so as to find any fault in the to find any perversity in the order dated 28/2023. Para. As an alternative submission, the learned counsel for the petitioner seeks accommodation to obtain instructions regarding the present status of the trial pending before the learned court in season. After the orders have been passed, after the present status के छाड़ दियंतु in season of the matter. केबे instruction आनी परिबे?
3 weeks. He's not
As
responding.
prayed for, list on. पांच तांकर भी प्रोडियल एंड फ्यूचर सुनी सुनी के बनमाली पूर्णचंद्र ये है कि 5/3/2024 किछि नाही मैडम केस रे दिस शुड नॉट बी केप्ट पेंडिंग
Old case minor, they are not responding.
they will not respond.
The deposition of PW1, my lord, they have stated that Bonnamali alias Paramanand is my younger brother. As clarified.
Yes.
तपर सेटा का सिटी तो ट्रायल रे हबो से ट्रायल रे जदी बनमाली को कहबे परमानंद कहबे ଶୁଣନ୍ତୁ ସାର୍, ଯଦି ବନମାଳୀ ପରମାନନ୍ଦ ନାଇଁ, ମୁଁ ଆକ୍ଚୁଆଲି ଆଉ ଗୋଟେ ସ୍ଟେପ୍ ଆହେଡ୍ ଅଛି। ବନମାଳୀ ଆଲିଆସ୍ ପରମାନନ୍ଦ ମ୍ୟାଡାମ କହିବା କଥା ଅଲଗା ଲୋକ, ତାମାନେ ପରମାନନ୍ଦ ଟ୍ରାଏଲ ଫେସ୍ କରୁଛି, ବନମାଳୀ କରୁନି, ଆସ୍ୟୁମିଂ ହାଇପୋଥେସାଇଜିଂ, ତାହେଲେ ବନମାଳୀ ଟ୍ରାଏଲ ଫେସ୍ କରିବ, ଆପଣ ପ୍ରୋଟେଷ୍ଟ ପିଟିସନ ଦେବେ, ହି ୱିଲ୍ ଗେଟ୍ ଦି ବେନିଫିଟ୍ ସେ କନଭିକ୍ସନ ହବ ତାର। ଆଉ ଯଦି ସେମ୍ ଲୋକ କହୁଛନ୍ତି ସେଟା ବି ସେଠି ସେ ପ୍ଲିଟା ସିଏ ନବ ବା ଆପଣ ନେବେ। ଆପଣ ଯଦି ସେମ୍ କହୁଛନ୍ତି ସେଟା ତା ଫେଭରରେ ପ୍ଲି ଡେଫିନେଟ୍। ଯଦି ଆଲିଆସ୍ ଗୋଟେ ଅଛି ତାର, ଦେନ୍ ଦ୍ୟାଟ୍ସ ଏମିତି କନଫ୍ୟୁଜ ଟ୍ରାଏଲ ହୁଏ ନାହିଁ। ଆକ୍ୱିଜିସନ ଆପଣ 313 ଷ୍ଟେଟମେଣ୍ଟ କଣ ଲେଖିବେ, 313 ରେ କାହାକୁ ପଚାରିବେ? ଦ ଟ୍ରାଏଲ ବିକମ୍ସ ଫାର୍ସିକାଲ, ଦିନେ ପଚାରିବେ ବନମାଳୀକୁ, ଦିନେ ପଚାରିବେ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ରକୁ। କେସରେ କିଛି ନାହିଁ ମ୍ୟାଡାମ, ୟୁ ସୁଡ୍ ଆଇ ମିନ୍ ଆପଣଙ୍କ ଥାକ ଯେତିକି ଅଛି ତାକୁ କ୍ଲିୟର କରନ୍ତୁ, ଏଗୁଡାକ ଆଗ ଫୋପାଡନ୍ତୁ, ତେବେ ଆସିବେନି।
Old case में they are
ସାର୍ଙ୍କୁ କୁହନ୍ତୁ ଏଟା ଫୋପାଡି ଦେବେ ଫାଇଲ ବାହାରେ। ୟେସ୍, ଆପଣ କଣ କହୁଛନ୍ତି ସାର୍ କୁହନ୍ତୁ?
ନା ଆମେ କହୁଛୁ ଆମେ ବାର୍ଥ ସାର୍ଟିଫିକେଟ କଲୁ, ସ୍କୁଲ ସାର୍ଟିଫିକେଟ, ଭୋଟର ଲିଷ୍ଟ ଆମେ ଠିକ ମାଇନର।
ଆପଣ ସେ ଭୋଟର ଲିଷ୍ଟ କୁ ପଳେଇଲେ।
ସବୁ ଆମର
12(3)A ରେ ଭୋଟର ଲିଷ୍ଟ କୋଉଠି ଅଛି ଆଜ୍ଞା? ଭୋଟର ଲିଷ୍ଟ କୋଉଠି ଅଛି?
ପ୍ରଡକ୍ଟ କରିଛନ୍ତି, ଆନେକ୍ସର କରିଛନ୍ତି ଏଥିରେ।
ସେଟା 12(3) ରେ କାହିଁ, ମାନେ ଅଲଗା କୋର୍ଟ ଅଲଗା ଲିଷ୍ଟ। ଆପଣଙ୍କ ସଲ୍ୟୁସନ ୱର୍ସ ଦେନ୍ ମ୍ୟାଡାମ। ମ୍ୟାଡାମ କହିଲେ ଯେ ତାଙ୍କ ଏଭିଡେନ୍ସ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା ବୋଲି, ଆପଣ ଚାଲିଗଲେଣି ଭୋଟର ଲିଷ୍ଟ କୁ। କୋଉ ମାଷ୍ଟର ଆପଣଙ୍କର ଜଷ୍ଟିସ ମହାନ୍ତିଙ୍କ ଜଜମେଣ୍ଟ ପରେ ସେ ପଢିଲେ ଯେ once it is available the magistrate cannot go beyond ସେ ତ ଲେଖିଲା next 1 2 3 is not available, next stage ତାହେଲେ medical evidence पे ଯିବ, medical classification test ହବ। Only in the there are series of judgments on this. Only beneficial legislation ଆପଣ ଯୋଉ ପ୍ରକାର କଲେଣି beneficial legislation ଅବସ୍ଥା ବାର୍ତ୍ତା ବଜେଇ ଦେବେ।
That is right, my lord. Only in the absence of either 1 2 3
ତାପରେ କମିଟି କରିବ, ନହେଲେ କୋର୍ଟ କରିବେ। ଆପଣ ପଞ୍ଚାୟତର ନେବେ, ଜନମତ ସର୍ବେକ୍ଷଣ କରିବେ। That's not permissible. ଲେଖିଦେବେ ହାର୍ଡ କାଉନ୍ସିଲ ଫର ଦ କଣ ସେଟା 5 and ଆପଣ 6 and 8 6 ଆଚ୍ଛା 6 ଦ ଲର୍ନିଂ କାଉନ୍ସିଲ ଫର ଦ ଅଫିସ 6 वाज आल्सो हार्ड। ଯୋଉଟା ଲେଖିଲେନି କି ସବଷ୍ଟାନ୍ସିଆଲି ଆଡଭାନ୍ସ ଆର୍ଗୁମେଣ୍ଟ ଯୋଉଟା ଲେଖିଲେ, ସେଇଟା ଲେଖିଦେବେ। ଆପଣ ତା ନାଁ ଲେଖିନାହାନ୍ତି, ତାଙ୍କ ନାଁ କଣ ପଚାରିଲେଣି ମତେ? ଏସକେ ମିଶ୍ର। ୟେସ୍ 55 ମିସ୍ ଦୀପ୍ତି ରାଣୀ ମହାପାତ୍ର। এটা দীপ্তি রানী নো, আই এম সরি, দীপ্তি রঞ্জন।
my lord, kept it pending.
হ্যাঁ
Pending ର
କଣ କରିବା, ସେ ଆରମ୍ଭରୁ କହିଲେ ଆର୍ଜନ କରନ୍ତୁ, କିଛି ନାହିଁ କେସରେ, କିଛି ନାହିଁ କେସ। The more I am trying to hear matters, it becomes more a roadblock.
Since my lord has already had, my lord,
ମୁଁ ସେଥିପାଇଁ I have dictated in the enough to dispose of the case. Whatever I have dictated, that is enough to dispose of the case. Only to accommodate the bar, only that old case A to satisfy. लिखे Mr. Dipti Ranjan Mahapatra for the petitioner submits that petitioner Mr. Opposite party Mr. Das, Mr. PK Das, PC Das, Mr. PC Das on behalf of PC Jenna for the petitioner. Sorry, I'm sorry, opposite party. Mr. Dipti Ranjan Mahapatra, Learned Counsel, submits that he has instructions to appear along with Mr. T.K. Acharya for the petitioner and may be accommodated to obtain instruction and file wakalatnama as paid for list on 29/2/2024. 56 obligations. Yes. Petitioner none. Mr. Upitu, Mr. Standing Counsel for State, OP1, Mr. Parthasarathi Naik for OP2. None appears for the petitioner when the matter is called to grant further opportunity. List on 26/2/2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024. 26 2 2024.
57. I pray for more time. Mr. B.K. Naik for the petitioner, Mr. Devashish Naik, AG for the state. The learned counsel for the petitioner seeks accommodation to obtain instructions. As paid for, Mr. Charitin could be placed to grant further opportunity to the petitioner. Chabis, I'm sorry, Chabisi, Charitin Chabis. 58. Petitioner none, opposite party blank. None appears for the petitioner when the matter is called to grant further opportunity. Disturb? 6-3 कोड़िए 24. 59. Mr. P.K. Malik.
That's it, DP Raichaudhuri.
DP Raichaudhuri. On behalf of Mr. S.K. Das for the petitioner. Mr. Devashish Naik, AG for the state. Learned counsel for the petitioner seeks accommodation to obtain operative instructions as paid for.
After vacation, adjournment.
Mr. 18. Kodo 24. 60. Miss M. Behra. On behalf of S.K. Ratha for the petition. Sorry, sir. Okay. Okay. For the petitioner. Hello. M. Behra on behalf of S.K. Ratha. M. Behra for the petitioner. Sorry. Miss M. Behra for the petitioner. Mr. Parthasarathi Das for the opposite party. Learned counsel for the petitioner seeks accommodation to obtain instructions as paid for list on 23 कोड़िए 24.
सब 2011 में लॉर्ड.
Yes.
आसुना 138 ना 50
से सकाळे आछंती.
अच्छा.
आपण जो नेगोशिएट करि परिबे करि डिस्क्लोज करंतु. Adversarial litigation is not working in NI Act. Yes. 61.
So, Lordship, in 61, I am for the decree holder, Your Lordship. This is a matter emanating from the court.
Objection affidavit in this matter.
You saw copy.
Your Lordship.
You are Miss Dinda, Minister Dinda, you are there for the petitioner in IA.
Yes, Your Lordship, and I am there for the decree holder petitioner. Your Lordship, I am a bit surprised because in an execution application, objections are generally because the court has to execute the decree.
Court takes note of the surprises on record. So that you have to surprise them by filing a written something.
That obviously will do, but Your Lordship kindly appreciate the fact this matter.
Filing written, it's not surprising.
Lordship, there is a Odisha amendment in this regarding.
CPC or amendment. We can file objection to the execution petitions.
That is, I am not coming the way, Your Lordship. Kindly don't take me amiss. It's just that.
Be fine.
Yes, yes, sir.
But since he's surprised, let him express his surprise in writing.
We will.
Surprise.
Yes. Actually, Your Lordship, we are suffering from last 20 years the decree.
So could you get the point what he said? The other counsel who is present, he has specifically stated. Oh, he is visible there in the VC.
Yes, Your Lordship, I heard.
Question there is a Odisha amendment.
Your Lordship kindly gives me 10 days to file a very short rejoinder to it, and then we can come back for final hearing.
Which petition I am taking up? That I am trying to understand. So that I can click it and see that. 6 and 2, yes. 6 and 7, both are
similar.
Your Lordship, both are same. 6 and 7. There are two companies basically, and there are two orders of sale.
You are filing the Mr. Devanshu Dinda for the petitioner. Miss Guman Singh. Yes, Guman Singh. And
same.
Okay.
I am for OP2, my lords.
Yes, Guman Singh for
GDN number 1.
You are JDA number 1.
Your Lordship. OMC, Odisha Mining Corporation Limited.
But here the cost title is.
Your Lordship, it was amended thereafter, Your Lordship. If Your Lordship remembers.
Mr.
They have served the copy, Your Lordship. The amendment.
The problem is that you have also filed it in a format ABC. It's not entertainable. It should be 1, 2, 3.
Your Lordship, this point came up.
It is a Kolkata. कौन लिख ले? For IDCOL now OMC.
Your Lordship.
For IDCOL, for OMC, JDA1, Sucheta Guman Singh, then opposite party number 2, Mr. Devasis Naik, AGA. OP number 3, you correct the cost title, bring it on in sync with the High Court rules. Because it becomes so difficult in small a, small b.
Your Lordship, I will ask my local advocate on record to do the same at the earliest.
कौन लिख ले? ये जी 3 ପାଇଁ क्या appear କରୁଛନ୍ତି? Anyone appearing for liquidator? ठीक है, blank कर दियंतु. The learned counsel, it apparently the cost title of the petition does not indicate the decree holder as the petitioner and the judgment debtors are the opposite party. In the as opposite party in the format provided in the High Court rules, as instead of 1, 2, 3 English likhive, they have been arrayed as a, small b, small c. The learned counsel for the petitioner seeks accommodation to renumber the cost title in description of the petitioner and the opposite party. Para. The learned counsel for the OMC files the response to the petition.
Okay.
The copy, the same shall be taken on record. You file it in the registry.
Problems.
The scanned copy shall be updated. Copy of the response in the form of an objection affidavit shall also be served on the learned counsel for the petitioner. Local counsel, whoever is there, on Mr.
Swamjit Raut.
Mr. Swamjit Raut and the learned AG appearing for the OP2. So should I record your surprise or not necessary?
Your Lordship gives me a time for 10 days to file a rejoinder to it. And then your Lordship may fix it for final hearing.
The learned counsel for the petitioner seeks liberty to file their response in reply to the response of the opposite party. Number 1. 2 weeks time granted. Para. 21, when it can be disturbed, in February or January?
No, your Lordship, in January 4th or 5th, because 2 weeks expires on 28th. So the next week comes to 4th and 5th. So any day, 5th January, 4th January, whatever your Lordship pleases.
Let it come on the 3rd week, 16th. 16th.
Your Lordship, can it be on 15th then? Yes,
yes, it can be on 15th. No, 15th is a holiday.
Oh.
So 15th is also a weekend here. I mean, the beginning of the week, 16th.
As your Lordship pleases.
Sankranti is holiday there also, I think.
Yes, as your Lordship pleases, 16th of January then.
No, I can't please to be hold it, take it on 15th because it's a holiday.
No, 16th then, your Lordship. It's
or you 22nd. I mean, the Monday.
16th. No, then it's fine on 16th. I did not know 15th is a holiday there. That's my difficulty.
It is the first day is 16th.
Then 16th, your Lordship.
Some item you are there. The same order.
Same
order. So the correction of the cost title. Instead of OP number small a, it shall be OP1. OP small b, it shall be OP2. OP small c, it shall be OP3.
Your Lordship, one indulgence, your Lordship. My local advocate on record just informed me that the same has been already done in the amendment, after the amendment, in the physical copy of the petition, your Lordship. But whatever it is, I will ask.
Submitted that cost title has been corrected by renumbering the parties. And the same has been filed on when it was filed.
Your Lordship, the same was filed on. I'll just ask the date.
Filed in the registry shall verify. The scanned copy shall be updated. Yes.
Grateful, Your Lordship. Grateful for
Yes,
the
please.
indulgence.
Yes, please. Uh, 62 Miss S. Sunandini. S. Sunandini. On behalf of Sarveshwar Behra for the petitioner, Mr. Devasis Naik, AGA for the state, Lord Counsel for the petitioner seeks accommodation to obtain up-to-date instructions in the matter. As paid for list on 27/2/24.
53.
Mr. P.K. Das for the petitioner, Mr. Devasis Naik, AGA for the state, Lord Counsel for the petitioner seeks accommodation to obtain instructions as paid for list on 28/2/23.
54.
Mr. H.S. Misra for the petitioner, Mr. Standing Counsel for the state, Learned Counsel for the petitioner, seeks accommodation to advance arguments as paid for list on 26/2/24.
65.
65 minutes, I will take of the instructions.
Sir, Prahlad Sahu, Mr. Prahlad Sahu for the petitioner, Mr. Standing Counsel for the state, the Learned Counsel for the petitioner seeks accommodation to obtain instructions as paid for list on 5/3/24.
Obliged minutes.
65 copy is not there.
Yeah.
65 copy is not there, man.
The Learned Counsel for the petitioner shall serve an extra copy on the Learned Standing Counsel.
Yes, ma'am.
Within 3 working days.
Yes, ma'am.
Yes, please.
56.
Petitioner none, opposite party, Mr. Standing Counsel. None appears for the petitioner when the matter is called to grant further opportunity. List on 7/3/24.
67.
Petitioner none, Mr. Standing Counsel for the state. Same order. List केवे करिए 7/3. Next, please.
68.
Same order. 6/3. Mr. Standing Counsel. Petitioner. Yes. Next, please.
69.
Same order.
69
Petitioner none, Mr. Standing Counsel.
copy is not there.
अच्छे तो नांती कौन करेगा? 70.
My lords, I am appearing item 70. My lords, this is a case in which the incident took place almost 33 years back, Your Lordship, on 16/6/1991.
Yes.
In which, as alleged by the victim informant, he is also PW1 in this case, that the accused person.
This is for against acquittal or against order of conviction, LP.
Yes, Your Lordship.
So against revision.
Revision, Your Lordship, against the conviction of the accused persons.
Okay. You have any instructions?
Yes, Your Lordship. As per my instructions, all of them are present. All the accused persons, they are present, and they want to pursue this case, Your Lordship. My lords, in this case, all of the accused persons.
Notices were issued.
Yes, Your Lordship. Notices were.
It has come for hearing.
Yes, Your Lordship.
And now, I mean, the only case that could have been heard that reaches at 4:15.
My lords, it is a very simple case in which the accused persons, as alleged by the.
So you have examined the judgment, seen the depositions. You have the copies of the depositions.
Your Lordship, I do not have the.
If you don't have the copy of the deposition, then don't start arguing.
No, Your Lordship.
Because you have to find out where there is publicity. That means where the learned trial court or in arriving, giving a return of guilt.
Yes, Your Lordship.
So what was the evidence? Whether there is eyewitness account? What is the circumstantial evidence?
The witnesses, those were deposed. They were on the eyewitnesses who were present at the spot at that time. My lords, it is a politically driven case.
Motive, madam, that's not relevant as far as appeal is concerned.
Yes, Your Lordship.
You should never. I mean, there's no point. You may say that, but there's no point in why it has been done. You have to strictly, and this is a confirming judgment.
Yes, Your Lordship. My lords, by the trial court, all of them were.
The magistrate convicted.
The magistrate convicted and the
Then
conviction
this
was
is confirmed by the sessions court.
even though it was confirmed, but the conviction was reduced. The conviction term was reduced to 3 months. And one of the
So what is the period order given already?
my lord, so to that effect, I do not have instructions.
So also you take instruction whether they will be satisfied if it can be converted to the period already undergone.
Right, your lordship.
Or if they will be satisfied
Yes, your lordship.
if they will be let off for the time being in the Probation of Offenders Act.
Yes, your lordship.
But yes, I am not compelling. I am not compelling.
Right.
But I mean, they have to. They will be having that stigma of being convicted.
Right, your lordship.
They will not suffer any further incarceration as of now.
Yes.
But the stigma of conviction will be there.
Right, your lordship.
So please take instruction on that.
Yes, your lordship. Then
and please examine if there is a convincing case to set aside both the judgments of the magistrate and again by the sessions court.
Right.
Because you see, I have to give reasons.
Yes, your lordship. I understand.
By dealing with the evidence or the evidence on record that was considered by both the courts.
Both the courts, yes.
Yes. Your name, madam?
Gautami Buddha Priya.
Gautami Buddha Priya. You appeared earlier, I remember.
Right, yes, sir.
Gautami Buddha Priya on behalf of M.S.Sahoo for the petitioner.
Right.
Mr. Devashish Naik, Mr. Standing Counsel for the State. The Lawyer Counsel for the petitioner seeks accommodation to advance further arguments. When do you want? In February?
Yes, but that will be all right.
To obtain instruction and advance further arguments as paid for list on 29th February 2024.
Oblige, your lordship.
71.
Yes, please. Mr. Ramesh Sethi.
I will pardon, item 69.
Just a second. 71 Ramesh Sethi on behalf of Chen Mahapatra for the petitioner. Mr. Standing Counsel for the State. The Lawyer Counsel for the petitioner seeks accommodation to advance arguments to obtain instructions as paid for list on 1-3-2024. Item 69, Mr. Swain.
I was absent.
69 adjourn he is already order. Non-appearance Mr. Chittaranjan Swain. Yes. To obtain instruction, 6th of March. The JJ Act matter, Mr. Standing Counsel, Mr. Naik would have been disposed of.
Yes.
But what can be done?